Testing 1, 2.
Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division are here. His attention shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. All right, so I'm going to give you my usual spiel, especially today. We have over 8 hours of requested argument time, okay? And I can assure you that your colleagues at the end of this calendar don't want to be here for 8 hours, okay? So I'm going to ask you to ask for that time that you actually need, not the time that you want, not the pie in the sky time, the actual time that you need to make your arguments. Please understand this court is familiar with your cases, the briefs, as much of the record as we could get through on some of these cases, and typically more than you wish we were familiar, okay? So get to the point, make your arguments, get in and get out, strike, make your strongest argument so that we are not here for 8 hours. That being said, let's start with the call of the calendar. People versus Tranell Smalls. Submitted. Good start. People of the State of New York versus Vidair Foundation. Okay. 5 and 2 and 5. G. Nita versus Jonathan E. Submitted. Perdomo versus 361 East Realty. Okay. 5 and 1 and 5. Rivera versus Masola. Okay, 5 minutes. 5 and 5. People versus Juan Garcia. Okay. 5 and 2 and 5. People versus Gerard Hines. Submitted. Carnegie House versus New York State Division of Housing Renewal. Okay.
Respondent 57th and 6th Ground, LLC, 3 minutes, please.
Okay, 5 and 2, 5 and 3. New Gold Equities versus Amgard Insurance is submitted. DKC Group Holdings versus Reese Inc. Okay, would you like to submit, seeing as the appellant has failed to appear? Okay, and could you please sit down until the rest of the call of the calendar before you leave? Thank you. Submitted. People versus Elias Ramos. Okay. All right, let's do 5 and 1 and 5. W. Faith is submitted. Jones Law Firm versus J Synergy. Okay. 6 and 1 and 5. People versus Paris Roberts, submitted. Hagen versus Robertson.
4 and 2, Your Honor, for the appellant.
Okay. 4 and 2 and 5. People versus Davon Jones. Okay. 3 and 1 and 3. Georgia Malone and Company versus E&M Associates. Both appeals will be argued simultaneously. Okay. Okay. Okay, 5 and 2 each for the appellants and 7 for you. Okay. People versus Javian Mazik, submitted. State of New York versus JP Morgan Chase et al.
Appellants request 12 and 3.
Okay.
Your Honor, on behalf of the respondent, I'd like to introduce my colleague, Seth Greenstein, and ask for permission for him to be heard today.
Is this a Pro Hoc Vici application that was submitted in writing?
It is, Your Honor, and it was granted by the court.
Very well. Welcome to the court, although we have hundreds of thousands of lawyers in New York, but welcome. Okay, and how much time would you like? All right, this is that one exception where we require this amount of time, so 12 and 3 and 15. HSBC Mortgage Corp. versus Lau. Okay? All right, we've been here before, so 4 and 1 and 4. People versus Derek Johnson, submitted. Chelsea versus Techner, submitted. First case to be called is People of the State of New York versus Vidair Foundation.
Good afternoon. May it please the court.
Good afternoon.
Your Honors, this is an appeal from a judgment in order of contempt that arose in a summary proceeding to enforce a subpoena.
How many times does a court have to tell you to comply with a court order and a subpoena? How many times?
Once, if it's clear, Your Honor, once.
No, it was clear. So attempts at, oh, I don't understand what you're saying, I'm not really sure what the extent of the disclosure is falling on deaf ears.
Well, if that's so, then I would say that the court needs to familiarize itself with the record, Your Honor.
I am familiar with the record.
there are
so
three
be real careful, counsel.
There are 3 categories of redactions that are permissible here. Donor information, donor/volunteer information, attorney-client privilege information.
Counsel, if the court directs that certain documents be turned over to the referee, why would you redact them before they were to reach that referee if that was the purpose of the referees reviewing them?
Because it is uncontested that the only redactions the referee would be doing would be pseudonymous or anonymous authors. It is very clear in the record that the referee is not to be touching attorney-client privilege redactions, and she's not to be touching donor redactions. And that is in the record over and over again.
But yet we're still here.
We're still here because the AG insisted on an ambiguous procedure that the court granted without reflection, and the court rewrote its order in October.
I love how you make determinations. The court made a decision without reflection. I just think it is absolutely disrespectful for you to couch your argument in those terms. You can say, I disagree with the court, but that clearly the court made this decision without reflection is outrageous.
Counsel, I want to read to you the section of the order. It's hereby ordered that Respondent Vidair is directed to electronically produce fully unredacted documents to Special Referee Rebecca I. Unredacted fully.
Right.
Nothing about the exceptions that you just made.
You're reading from 591 of the record? All
Yes.
redaction determination shall be done by the referee. The only problem there is that everyone agrees, including the referee from May 2024 and August 2024, that all redactions don't mean all redactions. To quote her own words from record 31415, she's there for a very, very, very limited purpose. The sole purpose, of course, is to review redactions of QPA.
So instead of abiding by the clear language of the order, you're going to substitute your own judgment based on all the rest of the colloquy during the conference. Is that what you're doing?
Not my own judgment. Again, look at Record 406. It was also the judgment of the Attorney General. It was also the hearsay reports from the referee herself. All redactions, everything unredacted except for what's permitted to be redacted. How is that not unambiguous? It is equivocal if anything is. We are entitled to be subject to an unequivocal order. We do not have that. We don't have that at all. And you don't need to take my words for it. Take the referee's words. Record 414. Attorney-client privilege is outside the purview of what I'm doing. Take the records of the AAG Richard Sawyer on 406. Obviously, privilege would be redacted. What do we do when there is a document that has QPA material and privilege and donor information? Where is it spelled out? In the January order? No. The December 2023 order? No. The March 2024 order? No. That incorporates the other prior orders. Maybe if the trial court had addressed the First Amendment issues at the outset, as we'd wanted them to do, this wouldn't be an issue. But the trial court did not do that.
What's interesting to me, counsel, is that a lot of what you're saying wasn't raised until the third contempt motion, right? So maybe if you had sought clarification prior to that, then maybe we wouldn't be in this. But it wasn't until the third contempt motion that now all of a sudden this is an issue. I just don't know, as my colleague started out, how many times do we have to be here?
And Justice Pitt-Burke, that's because it was not until August of 2024, prior to the third contempt motion, that anyone interpreted these orders as requiring Vidair to provide completely unredacted information.
Good afternoon, Your Honors. Andrea Trento from the Office of the Attorney General for the state respondent. I'd like to begin by, I think, approaching an issue that's not disputed. It certainly wasn't disputed in Vidair's brief, and that's that there are actually two buckets of documents that we're talking about here. There are the bucket that my friend referred to, the bucket that required some addressing by the referee that deals with qualified pseudonymous authors. There's another bucket, however. The court also in March of 2024 ordered Vidair to reproduce the documents that it had produced with extensive redactions, produce the documents that it had identified years earlier of electronic data that it had not produced, and produced corresponding logs. To the extent there was QPA in that material, it had to go to the referee. But to the extent there wasn't, they had to produce that information to the state. They did not. They did not by April 30th when the court had imposed a deadline. They did not by May 31st when Vidair said they needed until then to do so. Accepting that there was a stay that was imposed by the Court of Appeals at that time. They did not after the stay was lifted on June 13th when the OAG wrote to them and said, okay, it's time for you to produce your documents. They did not.
Was there some confusion maybe reflected in the referee's own knowledge that what she was supposed to do, what the court directed, was that clarified, and how was that clarified?
Your Honor, to the extent there was confusion, let me be clear. It did not have to do with the documents that Vidair did not produce that I referred to in my opening remarks. But again, with regard to the issue that my friend raised, it was clear to the referee that I think the Attorney General, Mr. Sawyer, was surprised by the extent of the existing redactions that there were. Again, the court had ordered Vidair to produce the materials it had previously produced with very limited redactions, the names of donors and the names of attendees to events.
Sir, I'm sorry, but did your colleague who handled this from your office below, did he or she view any of the relevant orders as ambiguous as to the requirements they put on your friend?
No, he made clear on page 408 of the record that to the extent any pre-existing redactions impaired the referee's ability to do her court-ordered task, then they were not permitted by the court's referral order. The referral order said all redactions must be done by the referee. If there's a redaction here or there that has information that has to do with information that is not within the purview of the referee, no one's gonna raise an issue about that. But they were extensive, and so we had to insist on following the letter of the law here. And Vidair refused to do that after that colloquy. And so that is independent grounds for the contempt order the court the court entered, in addition to, again, Vidair's months-long failure to produce documents that had nothing to do with the referee process. Unless the court has questions, we will rest on our paper.
I didn't mean to cut you off. If you have other arguments, you still have time.
No, that's fine, Your Honor. Thank you.
Any questions? Okay, thank you. Counsel?
Right, but the issue then becomes Vidair doesn't get credit for partial compliance and contempt. Either the order itself as a whole is unequivocal or it's not. And I'd mentioned Record 406 before. I was actually mistaken. Mr. Sawyer's words from Record 403 are, I thought the order was clear that almost nothing can be redacted except for obviously privilege or the name of donors, which is exactly the position that Vidair and anyone looking at this in an unbiased fashion would take. And the referee never maintained that this was an improper interpretation or anything else. This is what she agreed to as well. And you can look at her words, not just at 403, but 405. She says, I would be redacting the QPA information with all the addresses. The only thing with respect to redaction of something that would be redacted and given to me, I believe, it's from the original decision order, it does allow 2 categories of redactions. So at 405, the referee herself understands that she's going to be getting material that's partially redacted.
So the March 27th order that Justice Rosado referenced earlier
Yes.
states in part, quote, all redaction determinations and corresponding logging shall be done by the referee, end quote. What in light of that language leaves that order susceptible to more than one reasonable meaning?
Sure. The language, Your Honor, at page 590, that this order, the protective order, is in furtherance of the court's January 2023 order, which provided for those redactions. And furthermore, it says here, I mean, the purpose of this order here is to belatedly take note of a First Amendment issue that...
Counsel, I went to record 414 that you suggested I go to, and the special referee says, I need unredacted copies of the documents so that I can make my privilege log. And then at that point, I'm reporting and recommending to the judge. She goes further, line 10. Normally, it would be a privilege log, and then you would assert your attorney-client privilege. Was she able to do any of that with these documents that were set forth before her?
The answer is she was. She just said the process was cumbersome.
Thank you. Perdomo versus 361 East Realty. You may proceed.
Good afternoon. May it please the court, my name is Alexis Mantioni with Bongiorno, Montiglio, Mitchell, and Palmieri. I represent the defendant appellants, GF Enterprise.
Other than speculative statements and projections, what basis do you have to request these documents? You have to make a showing, and I see absolutely no showing.
So, Your Honor, I would state that our showing was made, and we did meet the burden.
With what?
Due to the fact that plaintiff in this particular case, we submitted the Medicaid records showing what treatment was submitted to Medicaid.
So
and
he
what wasn't.
decides to pay for his own medicine, perhaps because sometimes Medicaid patients, what is prescribed doesn't get filled as prescribed. And because of that, you're entitled to this loan information?
So it's more than that. It's the fact that at the time of trial, the plaintiff is going to go before a jury and submit evidence showing how his bills got paid and why he's entitled to money for past medical treatment. That should also include the funding, if the funding you...
So then it's your position that from this court, we should now say that in every one of these cases, that once the request is made, you're automatically entitled to it. Is there no showing, as my colleague said, that needs to be done beyond that? Because what you're asking is just for this bright line rule. Why would we do that?
Well, in the prior case that was decided by this court,
There was an actual basis for that one. There was a showing, there was a proffer that there was fraud going on with a mass bunch of plaintiff litigants in mass, and that the doctors, as well as the attorneys, as well as the litigants, were all in cahoots. There, the defendant proffered a real reason why these documents might be relevant. Here, you have not provided that. It's just, he's gonna get up there and say, I should be reimbursed. And so every plaintiff says that. So you are asking us to do a bright line rule saying the defense is always entitled to this.
so.
That would go against our precedent already in this court, so.
Understood. The problem, though, is that then the defendants can never, ever
No,
have a
no,
showing.
not ever. You just pointed to a case where this court allowed it. I was on that case. So it does happen. But what it requires is a showing that is not present here.
I
And
would,
if it is, tell me where. Where is it?
so while I am not directly going to say at this moment that we are alleging fraud in this case, we certainly have enough circumstantial evidence that we submitted. The list of doctors that was outlined that didn't bill Medicaid are all doctors that were named in multiple civil RICO suits, and both in the state court and in federal district
You're
court.
not suggesting that even doctors who may be involved in RICO litigation and who may be guilty of those cases, that every single patient they see now is a fraud case, right? You're not suggesting that.
Of course not.
Okay.
But
So the fact that some of the doctors also appeared in some of this litigation is speculative.
I think it's more than the doctors, though, and I think that needs to be taken into consideration.
Okay.
There's certainly complaints that name.
How did you show that in your, down below or in your papers here?
So we have annexed to the record multiple complaints. The plaintiff's office is the same as some that have been in the complaints. The doctors are the same. The providers are the same. It fits.
So where
the
there's smoke,
pattern.
there's fire. That's basically your argument.
No, but it should certainly be investigated, and at the time.
So now you're saying if there is a plaintiff's counsel who is involved in litigation, accused or suspected of being a part of these schemes, then every litigant that they represent now has less rights to privacy of their information by virtue of the lawyer they happen to choose, which they may not even know anything about this. That's what you're saying.
Well, it's not necessarily their right to privacy. They've brought a lawsuit, so they've waived a lot of those
Except
rights.
this is not discoverable normally, counsel. Can we agree on that? This is not normally discoverable. I see a wave of motions by the defense trying to open this door, but this is not something that routinely is provided in discovery.
I think it hasn't been as much of an issue as it is right now, and that's why you're seeing
Okay.
such an influx in the motions before you.
All right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent, and Justice Manzanet, apropos to what you said, I also know the Latuma decision because I'm the one who lost it. So let me just tell you, the facts in those cases was so different than here.
But Mr. Isaac, why isn't there where there's smoke, there's fire, right? Why isn't it where there's, all of these things are maybe lining up to head towards that kind of proof, but they don't have that smoking gun?
The easiest way I can explain it to you, I can do it actually factually based on the brief. Here's where we go. And let me tell you the page I want you to look at. If you look at the record 300 to 301, that's the operative report. That's the basis of the case. Now, the entity that did the surgery was Lenox Hill Hospital, okay? If you then go to the Medicaid billing records that my adversary talks about so much, 282 to 283, take a look. They billed Medicaid. So this stuff about the doctors being under indictment and the plaintiff's lawyer being under indictment are completely irrelevant. The entity that did this surgery is Lenox Hill Hospital. And I don't think this court should ever say that those entities, completely separate, are guilty of fraud because of an allegation. I would also point out to you, Your Honor, that the second department has just held, because this is going on all the time, as you know, and unfortunately I'm involved in a lot of these cases. In Drayton against Putnam, the second department just held that if you question an individual about a civil action without there being an adjudication, it's reversible error per se. And let me give you one more situation. I'm in a car. I get into an accident. My doctor does a fantastic job and I bring a lawsuit. If he's going to be charged with a crime, not adjudicated guilty of a crime, but charged with a crime, I'm now subject to fraud because I went to him? That's not right. I still remember from law school, one of my professors was quoting Justice Douglas, who's one of my heroes, and he said, and I think this is a quote, that guilt by association is the most odious tenet that we have in our law. And that's what this is. There is no proof here that the plaintiff ever did anything wrong. And let me go one step further, because you asked me. The case they relied on, the tradesman case, got dismissed. I don't want you to read the first opinion, because that's Judge Gonzalez's opinion is there. Read the second one. Read what he said about what those defendants did. The accusers became the abusers. This would be a terrible idea to allow litigation funding to come out, just like it would be a terrible idea for you to allow me, if I don't like a doctor, to try to subpoena all of his records on collateral matters. We should just try cases the way they are. And by the way, one last thing, and I'll sit down. I haven't tried a case since I'm 28 years old. I'm so old that when I tried cases, you could actually retain your challenges. That was the big thing. I can do this cross-examination, and I'm inept. Doctor, are you expected to be paid? Yes, I am. How much was your bill? $100,000. Do you knew he had insurance? Yes, I knew he had insurance. Did you bill the insurance? No, I didn't bill the insurance. Why didn't you bill the insurance? I wanted to get paid. Would that not be a situation where that could lead to excessive treatment? The doctor's going to say yes or no. And then the second cross-examination that they're going to do is say, doctor, do you have insurance? Sure, I have insurance. Do you use your insurance? Yeah. Have you ever done any surgeries? Yes. Did you process it through your insurance? This doesn't need to invade the plaintiff's privacy on something that's completely collateral. Any competent lawyer, and I'm certainly not a competent trial lawyer, can do it. And this is 40 years later. So I would just ask that you affirm the trial court's decision. Certainly not an exercise of, it wasn't an abuse of discretion. And it's congruent with this court's decision in worldview. Thanks for listening.
Thank you. You have 1 minute. I'm going to give you his extra 20 seconds.
So I just want to touch quickly on the fact Lenox Hill Hospital did bill for the surgery. The doctor didn't. The doctor is the one who is named in those civil RICO suits.
Well, let me ask you this. Let's assume that there is some indicia of fraud from a RICO standpoint. How would that be material and necessary to the defense of the personal injury plaintiff's action?
So I think the reality is that we went a little too deep on the fraud aspect, and I think the bigger issue that I'd like to redirect back to is the fact that as a defendant, we raise affirmative defenses in our answer, and one of them is that the plaintiff has a duty to mitigate their damages. In doing so, instead of something being billed to Medicaid that gets paid at a contracted rate, so let's say an initial billing code for a physical therapy is charged at $60. Medicaid is not paying $60, they're paying, let's say, $25. And then when the time that the case settles, the lien gets reduced to $20, let's say, all hypothetical. But that lien then gets reduced. The litigation funding loan is going completely in the opposite direction, so
I'm sorry
far
your
afoot.
time is brief here, but so traditionally or historically or typically, mitigation would be, plaintiff, you should have underwent the following type of treatment, or you should have taken the following type of medicine. Now it seems we're going a step further and we're looking at the manner in which the plaintiff chooses to pay for that service. Are you familiar with any authority that has expanded the mitigation concept to that point?
I'm not, but the near usurious rates of these loans cause that to be a problem. And that's why now you have a number, let's say that $60 now is getting paid at $60, but those loans are increasing at 30, 35, 36%. So by the time the case is done, whatever was charged initially at $60 might be 75, 80, 100, and then we're supposed to pay.
What's really going on here, and the real concern of the defense bar, is that this is going to impede settlement. Because we can't settle when I owe the loan servicer more than you're offering me. That's really what we're talking about, okay? I know I had these cases. I've been here a long time, but I haven't forgotten, right? So I know, I get it. But I can't allow that policy issue, that policy concern, which is what you're raising, to change the law that we have to follow, okay? So I say this to you because I don't want you walking away feeling like these are never granted. They are granted. You just simply must make a showing beyond every time someone takes a loan, we should get the information, which is really where we are. But thank you.
Thank you.
Have a good day. All right. Rivera versus Masola. You may proceed.
Please the court. I'm Shore Stone from the law firm of Carmen, Callahan, and Ingham, and I will keep it brief because I know we have a lot on the docket today, and you're familiar with the papers. Quite simply, it's simply not considered plaintiff's violation of VTL 1284, sections 1 and 3 in its decision. Plaintiffs at his own testimony established that one, plaintiff entered the roadway from the sidewalk without stopping. Plaintiff's view was obstructed due to a white van parked on White Plains Road. It was plaintiff's intention to enter the roadway against the flow of traffic on an electric scooter, and plaintiff entered that roadway against the flow of traffic.
And so, sir, you assume you've made a prima facie showing that the plaintiff failed to exercise due care under common law negligence and violated certain VTL provisions. Would that establish negligence on the plaintiff's part lead to the dismissal of the complaint, or was that be an issue of comparative fault?
I believe it would be the dismissal of the complaint, as my client was in his own lane, which is testimony during deposition and on the police report that he was maintaining in his own line of traffic. My friend to my right submits that we moved into the parking lane, which is after every accident, someone goes so that the traffic can continue. In this case, it is clear that he's in the right lane, closest to the white van that the scooter then cut across.
So it's the synergy of your client discharged his duty to exercise reasonable care, and that plaintiff did not.
It's not that he discharged his duty, he used whatever duty that he had and maintained in his lane the whole time, and it was a matter of seconds before plaintiff didn't stop, which he's required to do so under the VTL, didn't stop, went in front of the van, and then was struck. So my client had little to no ample opportunity to stop the car, which is submitted in the papers. If the court doesn't have any questions for me, I can rest on the brief.
Counsel?
Yes, may it please the court. Represent plaintiff. Now, in this case, is the issues of fact. This accident occurred when the plaintiff was driving his scooter. He did leave the curb, and he said he left the curb in front of a white van. Now, if he had stopped at that curb, he's still facing a white van.
Right, but doesn't he have an obligation before entering a traffic lane to make sure that it is safe to do so?
Right, and according to his testimony.
He said he did, and he saw nothing, but was hit immediately. So I can't square that, right? Because he should have been able to see what there was to be seen if he had indeed looked.
Well, there's more to the story. Basically, if you have the white van is there, and he leaves the curb, and now he testified that he's moving up so he can see what there is to the left. He said when he poked the little scooter wheel.
Well, I would imagine that the scooter wheel enters the roadway before his face is able to look around the van.
Well,
and by then, he is hit.
Exactly.
Which means he chose the wrong spot to break into that lane.
Well, it must be considered, too, that is a driveway from an IHOP, so it's not like he just left the curb. So he left where cars normally leave. And if you're out one of those scooters, your nose is above the front wheel.
It's not.
I've never driven one.
Come on.
They got those little wheels
Come on.
this. Anyhow, we could differ over that. But he stuck his head out to see if there were cars that coming. That's when he got hit. Now you say, why did he get hit? because the defendant was driving close to the white van because it was his intention to make a right-hand turn onto Bruckner Expressway. He admitted that in his deposition. I was moving to the right, I was closer to the right because I was going to drive, and even...
But he was in the right driving lane, right? He wasn't in the lane closest to the curb.
he was in the process of changing into that lane. That's why...
Well, there were cars parked right next to the curb. I mean, in the pictures, there were cars parked. He testified, and I didn't see anything different in the record, that he was in that lane, that right lane the whole time.
Yes, and he was moving, he was in the process of moving into the parking lane. And
You're
that's
saying
why...
he's moving a little farther over, but he's still within the lane he's allowed to be driving.
Well, where does the lane end and when you're so close to a parked car? If you're driving down the street, is it
Well, you
reasonable to
clearly
park?
can't go into the parking lane if there's a car parked in it, right?
Right, but he was
So
angling.
all he could have done based on your argument is hit the parked car. So your argument is he hits this pedestrian because he was moving so close to make his right-hand turn that he would have hit the parked car.
No, I'm not saying that at all.
Okay, so then if he's not hitting the parked car, that means he's staying in his lane.
He's in his lane, but why is he driving so close to parked cars? If the lane is...
Why is your client peering out when he can't see?
Issues of fact. I agree. There's issues of fact as to why. And there's one thing we have to understand. Their claim is that he darted out, that he came and he didn't have time. The plaintiff never saw him. And
Did your client actually testify? Because maybe I missed this in the record about the lane change at the moment of impact, or was it before or
Right.
after? I mean,
he testified that when he first saw the vehicle, when he was further back, the vehicle was in the lane closest to the double yellow, and that's where he saw, when he was back further, he saw there were no cars in the immediate right-hand lane. And so then he went out to peek his head out to see if anything had changed, and that's when the accident occurred. Now, there's one thing you have to...
but was there? But I mean, even assuming this car changed lanes,
Yes.
is there anything improper about the change of the lane? I mean, you're allowed to change lanes when you're driving.
You're not
You do it
allowed
all
to.
the time.
You're not allowed to drive in the parking lane.
He wasn't driving in the parking
That's
lot.
where we was going.
You just said he wasn't parked. When I asked you earlier, counsel, please.
No, but I'm
okay?
saying,
When I
you
was asking you
misunderstood me, Your
questions
Honor.
earlier, I asked you, was he driving in the parking lane? No.
He wasn't
And now
moving.
you're saying, well, when he's moving and gonna go drive in the parking lane,
He was
one or
moving.
the
His
other.
intention is, according to his testimony, he was moving into the parking lane to make a right.
He said he was intending to turn right at the corner.
No,
I'm
he-
familiar with this intersection.
I am too.
Yes.
I am very familiar with that intersection. But we have to understand one more point, is that the defendant hit the plaintiff with the front of his vehicle. This is not him driving into the side. He hit him with the front of the vehicle. There was a dent in the bumper. There was a dent on the
He
hood.
doesn't deny that. He just says he came out of nowhere
He never saw him.
because he was behind the white car.
But at some point, he does materialize in front of the car, in front of him. He doesn't say he didn't have enough time to stop. He doesn't say I saw him and had to apply the brakes. He said he never saw him.
What was the point of contact between the bike and the van?
It was the front wheel of the bike and the right front aftermarket bumper and the right headlight. There's a dent. And he even testified afterwards they couldn't find an aftermarket bumper to replace it, so that he left it off when the repairs were made to the vehicle. There was also a dent on the hood and followed up with a body roll onto the windshield. Initially, it was argued by the defendant that he ran into the side of the vehicle because the mirror was broken. That was his body rolling on the vehicle that broke the mirror. So my point is that, yeah, there's a duty for the plaintiff and there's a duty for the defendant, and it's an issue of fact as to the negligence of each, and if so, how much.
But we have cases that just involve, let's just say, vehicles. When a vehicle is entering a roadway from a parking lot, isn't that where the duty lies, right? To observe what is actually in the roadway so that the person entering into that roadway there's not an accident, right? That's normally how we do it. So now we're gonna, change the vehicle entering into the roadway to the scooter. Why does that change? He's subject to the same rules of the road.
I'm not saying it does change. I'm just saying that the defendant, according to the testimony, hit him with the front of his vehicle and never saw him, and he had a duty to see him. So there's negligence. There could be possible negligence on both sides. It's not a summary judgment situation. The jury would have to decide.
So in cases where this court has held that someone who is struck by a car because they dart out into the street from between both cars, we've done that.
Yes, but-
Right? So how is it different that a scooter does it and somehow there's a different analysis that is at
Because he didn't
play?
dart. There's no evidence that he darted. There's no evidence that he darted into, where is the
Yes,
word
but
dart?
as a vehicle, he has an obligation to enter that roadway only when it is safe to do so.
Well, let's take a car.
And no. He has the obligation, right? Because the defendant here was traveling on a thoroughfare, straight,
That is correct, but
right? So the car coming into the lane is the one who has the duty to enter that lane of traffic safely.
so say there was a car coming out of this lot.
Counsel, you're not gonna give me a hypothetical.
No, but-
I thank you because I just made a statement, didn't ask a question.
Thank you.
But I understand your arguments.
Thank you.
Counsel, you have a minute.
I would just like to say that the scooter was weaving in and out of traffic. It was on the main road, then went into a sidewalk, and then tried to exit.
But we don't need all that because at the time of the incident, that's not what was happening, right? So what he did ahead of time, whether it was wrong or right, and I agree with you, you're not supposed to be driving a scooter on a sidewalk, right? But that was not part of the reason for this accident at the moment, right?
Yes,
So let's not go there.
and we won't go there. But his failure to abide by the VTL 1284, 1 and 3 is the reason of this accident. Again, I'll just reinforce that my client was in his lane the whole time. He actually merged from the left lane and testified that he merged from the left lane to the right lane approximately 7 to 10 car lengths previously. So what has to be seen is there. And any questions to the court? I'm here.
Thank you.
Thank you.
Thank you, gentlemen. People versus Juan Garcia.
Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellate Juan Garcia. Your Honors, this case involves a suppression issue and excessive sentence issue. I would like to start with excessive sentence because I think it's important to become clear on what the facts of this case are. The prosecution in their brief framed this as a cold-blooded murder in which Mr. Garcia hunted down Mr. Sierra and his friends. That is simply not supported.
Well, it certainly was a senseless murder. A man died because he flipped somebody off.
Yes, Your
Right?
Honor.
At the end of the day,
Yes,
this
Your Honor.
young man lost his life because he flipped the bird to the defendant's son.
Yes, Your Honor. I just want to make it clear that it was.
Yeah, but I want to be clear because you're kind of like softening. No, this is a manslaughter.
Yes,
This man was stabbed so hard that the knife came out through his back, right?
Yes, Your Honor. Well, the record is like, the knife coming out of the back comes from the mother's statement. I don't think it is otherwise in the record, but yes, he died. Obviously, this was a hot-headed, terrible decision that Mr. Garcia made, and no one is denying that. I just want to be clear that it's not a cold-blooded murder. And so the question in terms of excessive sentence in front of the court is, does that single moment, is 17 years of incarceration what is the minimum incarceration necessary, balancing the needs of the community for justice in this difficult situation, this terrible situation, versus Mr. Garcia's personal position. This is the only crime he has as an adult. He was
only
47.
felony.
Only crime at all as an adult.
Because he has had arrests with knives in the past.
He had a misdemeanor when he was 17 as a minor. There was another arrest mentioned that did not turn into any sort of conviction. We don't know the details there. I don't believe there was a knife involved in that one. So given those circumstances, and for the reasons laid out in my brief, he was married for 30 years. He had children. He was in the community. This was a terrible choice, yes, but it was in a single moment. And that is the argument on excessive sentence. Just we would ask that you look at that, consider that is 17 years necessary, over 3 times the minimum. And as to the suppression issue, I know there's a factual issue here about whether or not there was a yes before the equivocal statement. first, I just want to emphasize the idea that there was yes, sorry, you look like you had a question. If the idea that there was ever a yes was only ever brought up one time, but regardless, I just want to make clear, because I'm not sure if it's clear in the briefing, our argument stands, even if the witness did originally say yes, when he was asked to actually make the identification, he responded, he was only pretty sure of the identification, and that should have triggered follow-up questions, whether or not he said yes first for the reasons laid out.
Was that all yeah, okay, go ahead, sorry.
Yeah, for the reasons laid out of my brief.
Would you like to get out in front of the
appeal waiver? Yeah, I was expecting that question. Yes, I mean, again, I feel like I'm just reiterating my brief here. I don't want to waste too much of your time, but there was an appeal waiver, but Mr. Garcia's full understanding of the waiver was not made clear on the record. Again, as just discussed, this was certainly his only felony, his only crime as an adult. He was not someone who was familiar with the criminal legal system, familiar with appeal waivers, and the judge here relegated all discussion of what rights survive an appeal waiver to an off-the-record discussion with his attorney. When he came back on, they said otherwise, basically, this waives most things, go talk off the record to find out what it doesn't waive. When he came back, she reiterated, do you understand that this waives most rights other than the ones in paragraph 1 in that waiver you looked at? But to which he did say yes, but she did not ever ask, did you understand what was in paragraph 1? Did you have an opportunity to ask questions? Do you have any questions for the court? And given particularly that this was Mr. Garcia's first interaction with an appeal waiver.
This case had been pending for 4 years.
Yes,
so I'm certain that there had to have been at least 24 appearances, opportunities to consult with counsel. It would be clear that on a case like this was the product of long negotiations between the people and the defense and probably the court too, right?
Your Honor, I can't speak to when this particular bargain came.
Well, he was arrested in 2017 and the plea was in 21, so we know 4 years went by and a hearing was held.
Yes, Your Honor, though it was also very shortly after he'd lost a suppression hearing, so it's very plausible that he wasn't even thinking about taking the plea until that point.
That's typical.
Yeah,
you and I both know that.
Of course,
right?
But
it's after the suppression hearing. If you lose, typically the cards fold.
Regardless, the court, in terms of the appeal waiver, the Court of Appeals is clear that the understanding, no matter how long it had been going on, the understanding does.
You mentioned that the court didn't ask, were there any questions for the court? Where is that required?
That isn't necessarily specifically required, but what is required is making the defendant's understanding of what terms he is and isn't agreeing to clear in the face of the record. Often a judge will do that by actually explaining themselves all of those terms and then saying, do you understand? Here we never had a point where he actually said, I understand what's in paragraph 1.
We've read 1,000 different versions of these. Trust me, we know. But you'll have time on rebuttal. Counsel.
Good afternoon, Your Honor. It's Joseph Tucker for respondent. I think.
Well, counsel, I just want to start with the appeal waiver, because one of the things that the court says is if you waive your right to appeal, if you understand it, feel free to sign the form and counsel you as well. Okay, is that? I don't know if I want to say sufficient or a proper way to ask that question, but how do you get someone's understanding from that? Feel free, just go ahead and do it.
I don't think that language is perfect there, but I think that in light of the totality of circumstances set out in Thomas, I think this is a valid waiver which precludes the excessive sentence and the denial of suppression hearing. I think if you, contrary to what counsel says, the court didn't just rely on the written waiver. The court told the counsel and defendant that the plea relied on the waiver, that he explained that you have the right to appeal any decisions by the court, any errors made by defense counsel or the prosecutor. He explained an appeal to him, and he directed him to the waiver, which was more detailed, and then subsequent to that said to him, I want you to understand that this is final other than those rights set forth in paragraph 1. So it's not one of those cases where he was completely silent in the oral colloquy. The combination of the oral colloquy with the written waiver, I think, satisfies Thomas.
And then on the issue, should we get to the issue of excessive sentence, do you wish to be heard?
Sure. I mean, the court pointed out the fact of the nature of the crime here. This wasn't a situation where, spontaneous, he turned around and stabbed someone who was attacking his son, which is what he said eventually when the court gave him a chance to speak at sentencing. He got in his car, he drove around, he looked for the black car that struck his son's car. He came back, he picked up his son, went out again, and he found the victim at the end of the street. The victim was pushing the car door to keep his son in. At that point, he could have driven away. He chose to get out of the car with a knife and stab him, and he killed him. This wasn't a spontaneous situation. So he had a lot of time to make up his mind. And it's important to understand that when that black car struck his son's car, he called 911.
To be clear, there were two incidents.
There were two incidents.
Two different
Yes.
situations with his son, but the young man who was killed was not the one who was not in the car that struck the
No, he was the second incident where he flipped the
It was
bird.
just the flipping of the bird.
Right, and the father took his son, drove down the street, and committed the homicide. So I would say that not only is the waiver valid, and it precludes this claim, but in light of what happened here, the court was pretty upset with the fact that the defendant didn't admit guilt to probation. And the court gave the defendant another opportunity during sentencing to admit guilt. Not only did he not do that, he blamed the victim. I don't think this sentence is unduly harsh. It's a tragedy that someone died, and it's a tragedy someone spending 17 years in jail. I'll agree to that, but I think that the court was right, and I think the waiver precludes any excessive sentence claim. If there's nothing further, I'll rely on the brief. Thank you.
Oh, she has rebuttal time.
I just want to speak to, in terms of the accepting guilt, I do think it's pretty clear on the record that Mr. Garcia chose not to speak to probation because his attorney advised him not to get into the facts, which was perhaps bad advice here, but he said he did, in fact, tell probation that he was guilty of what he'd pleaded to, so that seemed to have been a miscommunication. He did later say, yes, I did stab him.
No, it wasn't that he denied stabbing him. The problem was that even at sentencing, he felt that the victim was at fault for this altercation happening. If you had not flipped off my son, this altercation wouldn't have happened.
I would like to clarify, it wasn't that he'd flipped off his son, it was that when they then drove by them, stopped to reconfront them, then there was, as we discussed, the closing of the car door when the son did get off, the throwing of water at the son, which does not justify stabbing him, of course, but I do want to just be clear, it wasn't that he saw him flip the bird, he wasn't even there when he flipped the bird and decided to track him down, it was that then there's this conversation that he felt was a threat to his son, obviously an over-escalation, no one is denying that he now feels regret, but I just want to be clear that it was spontaneous. It was because of this tense moment where he had this overreaction.
So your client didn't have to get in the car and go follow the guy that flipped the bird.
Your Honor.
We wouldn't be here today.
Your Honor,
Counsel, will we be here today if he chased that car?
Your Honor, I think the record doesn't support that he chased the car. He was still looking for the black Maxima and happened to come upon them. That's what is in the record. So I think that's part of my point here is that it was actually spontaneous. It was hot-headed, and that doesn't mean it was okay, but it was different than this cold-blooded tracking down. And that's all we're asking here is that you consider that when you're considering whether or not this is excessive sentence was excessive. Thank you.
Carnegie House versus New York State Division of Housing.
Good afternoon, Your Honors.
You may proceed.
My name is Timothy Collins. I represent Carnegie House and several of its individual shareholders. And we are here today to talk about a declaratory judgment action that was determined not to be ripe. The lower court dismissed the action.
So did the shareholders of this cooperative corporation, did they pay in, did they buy their apartments?
Yes, yeah, it's a regular co-op. At one point, it was a fully rent-stabilized building. It converted, and over time, the shareholders joined in.
And now we're concerned, or you're concerned, that there could be a deconversion?
Yes.
Go back to a rent
In
stabilized?
fact, a deconversion is rather imminent. A notice of default has already been issued. That's actually mentioned in the opposition papers. And there is a parallel track. There's an arbitration proceeding that has come to a conclusion but is subject to an appeal. So there is some possibility, and there's also a standstill agreement. In effect, there's a possibility that we have a little bit of life left, but we have 324 shareholders who are on the verge of losing their equity, and many of them are facing the consequences of deconversion.
Sir, I'm sorry. Was the motion to confirm that arbitration award, is that still sub judice, or has that been granted?
No, that motion was granted, and it's under appeal.
Okay.
Is there still there was a Yellowstone, I think, by the judge, so that holding the time.
There was for an extended period.
Is that still
And
existing?
you know, I really don't want to go into the arbitration issues because they're not before the court now. At the moment, the arbitration is over, but subject to appeal. So we're in a situation where, I mean, the obvious question I would anticipate from the court is, well, didn't these folks know what they were getting into? This is a ground lease. Why would they buy into this knowing that this is subject to renewal? Well, you know, the ground lease was, and you know, the formula, which is a pretty draconian, was formulated in 1974 when the ground lease was renewed back then. The co-op was converted in 77. So while it may be true that there was, on a contractual track, that folks knew what they were getting into, and on a contractual track, there was this arbitration process that would set the ground lease rents. I'm not here to argue about the contracts. I'm here to argue about statute. And I think the issue here is, does this statute protect these shareholders? Now, the main objection is that, well, they're not rent stabilized yet. They haven't fallen over the cliff through deconversion. So we're not going to tell them what the consequence of that fall will be. We will not tell them how far they're going to go. We're not going to tell them what their rents will be. The DHCR has a regulation which effectively says, and it's a little more complicated than I'm describing, but effectively says that an owner can come in after deconversion and basically say, you know, your rent's whatever I tell you it is. You can take it or leave it, and if you leave it in 120 days, your tenancy is over. So that's the great fear. That has affected things because not only is there an arbitration process that's gone on, but there's been a negotiating process. And this regulation, which is, we believe is invalid and completely out of harmony with the enabling law, which says there has to be reasonable protections against the housing shortage and the setting of rents, what we consider an ultra vires regulation has been weaponized by the owner in negotiations. Basically, the tenants are being told you're going to, you know, have market rents or possibly even higher than market rents because there's no protection. Theoretically, the owner could walk in and say, you know, your rent's $1 million a month. See you later.
So, sir, could you?
I'm sorry.
Go ahead.
Just a small question. And so your argument is that by the time all of the processes that would actually maybe make it right, by the time that happens, the harm has already been done and it's too far gone.
Is done, and you know, one can take what I think is a myopic and technical approach to the regulation and talk about things like zone of interest, which DHCR has done, and say that, well, these folks are not within the zone of interest because they're not yet rent stabilized. But the regulation itself exempts co-ops provided that if they do deconvert, then they have these various protections. And that's what's at issue here. And as the court knows, whenever you enter into any contract negotiation, let's say, for example, you're buying a car on installments, understanding the consequences of a default is really part of what you think about when you negotiate. are they going to get a money judgment against you? Are they going to repossess your car? Are they going to send you to debtor's prison? You want to know that before you enter into an agreement. And here we have a provision that we believe is invalid, that has been weaponized by the developer, the owner, in order to gain bargaining leverage in negotiations. And we just want a clarification of what the law says.
Isn't there some kind of provision in the statute that said that if the owner of the ground lease is actually responsible for affirmatively causing the deconversion, that you have certain additional rights at that time?
Yes, but again,
And under the facts here, certainly that would be an argument that the parties here could make.
absolutely, we would make that.
So why then would it be appropriate for this court to issue what in essence you're asking for is an advisory opinion? That is not what this court does.
Well,
Ever.
in
We
cases,
never do that.
right, in cases where statutory provisions or regulations, and the Community Home Improvement Program is probably the closest case on point analogous here. 1987, the Rent Stabilization Code was revised. The owners challenged it and said it was.
But in that particular case, I mean, it starts out by saying, after seeking pertinent rulings from the defendant being DHCR. How is that similar?
Yeah, no, it's a good point, Your Honor, but when they were before the court, they were simply asking for a declaratory judgment as to the validity of the new regulations. Regardless of what might have gone on in DHCR, they were asking the court. And the second department said, yes, of course, the new code has an impact on your interests. And whether or not there's an immediate factual dispute or not, and you're challenging the validity of it on its face, and you're entitled to know what the law is. And one of the troubling things about this case.
All right, no. I'll give you time on rebuttal
good.
because
Thank you, Your Honor.
we were going to go off on a 10-minute talk there.
Good afternoon. May it please the court. My name is Stephen Beard for the New York State Division of Housing and Community Renewal, also known as DHCR. The court below correctly dismissed the amended complaint in its entirety because the claims are not ripe and
But I mean, there is something to be said that by the time the claims become ripe, maybe it's too late at that point. What isn't there significant harm that's already occurred by the time it becomes ripe? Or is that not the case?
there is no harm at the moment because there's the ground lease is not terminated. It's not, as of right now, it's not set to terminate until 2046, as recently renewed by the appellants. And if there is a deconversion, they have two choices. They can seek relief from DHCR, or they can seek relief from the courts, which have concurrent jurisdiction over these matters.
I guess it might be cathartic to get an answer up front whether this is this regulation even applies or is unconstitutional, rather than going through that whole process and all the vagaries in that process.
If, for example, a court issued a declaratory judgment tomorrow, and then the day after, the appellants and the ground lessor extend their ground lease, they extend they figure out whatever ground lease rent they think is applicable, then that declaratory judgment was an advisory opinion. They never deconverted. There was no deconversion.
You put into your briefs, and I don't know if it was the ground lease attorney or if it was you, that there have to be like 8 things that have to happen before they can even bring a case. By that time, this could be a long time from now, and it may be too late.
I believe that was my colleague's brief.
Position.
Our position is, until the ground lease terminates and there's a deconversion, the claims are not ripe. They also don't have standing. Standing requires 2 elements. You have to have an injury in fact, and it's got to be within the zone of interest. As the second department held in Buckingham v. Duty, which is cited in the brief, property tax assessments for former condominiums that had been subject to the Emergency Tenant Protection Act are not within the zone of interest of rent regulation. Just as it says here, ground lease rents and the negotiation of those ground lease rents are not within the zone of interest of rent regulation, which the state legislature expressly excluded from the coverage from such regulations.
Sir, did I understand your friend correctly that the motion to confirm the arbitration award was granted?
That is my understanding. It's not in, of course, in the record. However, I do, having checked the recent NYSEF filings for that case, I did see that there's a standstill agreement where the ground lessors agreed not to terminate the lease while they negotiate a resolution of these matters. And I think there's some time frames that they set in that provision that in the case cited by the appellants before. So I think that establishes that they're still not terminating the lease. They may never terminate the lease. They may instead elect to seek purely monetary relief from the courts if they don't work out their matter. We don't know that they're going to serve a notice of termination. Until the termination actually occurs, the case is not ripe. And with that, Your Honors, we submit on the briefs unless there's any other questions.
Good afternoon, Your Honors. I've pleased the court, Stephen Meister for Respondent 57th and 6th Ground LLC. To answer the questions of the court, there was a petition to confirm the award. There was a cross motion to vacate the award. It went to Justice Moyne. He did confirm after some time. However, that was appealed, and immediately after the appeal, an application was made to this court by Carnegie House through different counsel for a stay. That stay application was withdrawn because we resolved a standstill on consent, which counsel for the DHCR was referencing. We haven't served a termination notice.
Sir, maybe you can walk us through specifically now that the arbitration award has been confirmed, and we understand there's an appeal, what are the other material events now that would lead to deconversion?
Okay. First of all, we would have to serve a termination notice after non-payment of the confirmed rent. Okay? I can assure Your Honors that without the advisory opinion they're seeking, this landlord is painfully aware that that process is fraught with risk without this court's opinion because the DHCR can say what they're going to say, and you can have an Article 78 proceeding about the DHCR. So this landlord well understands the risks associated with the termination notice and has not terminated. And I would point out, we could have served a termination notice after Justice Moyne issued a decision and dissolved his TRO. There was a restraint with a very small bond. We didn't do that. We didn't do that because we understand the risks. We don't need this court's advisory opinion for us to understand the risks in this state and this city of a deconversion. We don't want a deconversion to occur. If we don't, I think we will come to terms, but if we don't come to terms, we have monetary remedies. I do want to quickly point out—
Of course, at this juncture, we wouldn't be giving an advisory opinion as to the constitutionality or applicability of the code provision. We'd be saying that the plaintiffs have standing, so we're not shutting the courthouse door, so to speak.
Well, here's how I'd answer that. I think there's a one sentence in the appellant's brief that I think answers this question. In the appellant's brief at pages 23 going on to 24, the appellant said, if the landlord understood that the rent stabilization code would protect newly stabilized tenants from excessive rents on deconversion, it would almost certainly cease its efforts to destroy the cooperative. It would negotiate in good faith to achieve a ground rent that is sustainable. And on reply, the presence of the challenge section has poisoned balanced negotiations. I don't think that's correct, that assessment, but nevertheless, what that means is that counsel for the appellant is saying, please declare that this law is invalid, because if you do, then Mr. Meister's client will be reasonable, will make a deal, there won't be a deconversion, and the statute will never apply. That is a quintessential advisory opinion, because they're looking for an opinion for the purpose of averting deconversion, which happens if we do a deal. And I tell you, I think, this landlord understands these risks, and therefore the advisory opinion is unnecessary, but it is an advisory opinion. We'll rely on our briefing, Your Honors.
Yes, very briefly, Your Honor. Just basically in response to what Counsel Meister has said. Again, what's happening here is that an invalid provision of the law, and this is what's unique here, has been weaponized in negotiations. It's clear and it's been admitted that negotiations are continuing. This will only settle by negotiations unless something dramatic happens with the arbitration.
I'm sorry, sir, is the injury, in fact, the weaponization, in your words, of this, the code provision?
The injury, in fact, has been that the owner's position has been that they can charge us any rent that they want upon deconversion. Notwithstanding whatever has been said to this court, the reality is that the co-op shareholders are being told that the landlord can step in and charge what they want. They have basically been holding a gun to our heads in negotiations saying, you know, either take this very high and completely unsustainable rent increase from a little over $4 million to almost $25 million per year, almost a six-fold increase in rent, or face deconversion. Clearly, they don't want deconversion because there's going to be more litigation, there are going to be more battles and that sort of thing. But by that time, the proverbial horse has left the barn and a tremendous amount of damage will have been done. You know, people will lose their equity and people will be facing displacement. And the only thing that we ask this court to do is to let the lower court or instruct the lower court decide whether or not this is the scenario they will face. Is this regulation valid? And we think clearly it's not. And what is amazing about this is DHCR, for over a year, the agency charged with promulgating and enforcing this, has not defended the substance of it. There's nothing more arbitrary under the law than to have a provision of law that they say, well, we don't really know what it means. We don't know if, you know, we're not going to defend it. We're just going to tell you can't challenge it.
What would the concrete effect be of us siding with you here and then the lower court siding with you on the merits? What would the concrete impact be of ruling in your favor?
The concrete impact would be that DHCR will be sent back to the drawing board to promulgate a valid regulation that's consistent with the enabling rent stabilization law. And that may not occur right away. I mean, that's obviously a months-long process. But in that context, if both parties know that we're going to get some clarity as to what the legal landscape is, then there's I think a fair possibility that we'll be able to have a resolution of this short of deconversion. So, yeah.
Thank you so much.
Thank you.
Thank you. DKC Group Holdings versus Reese. Counsel, you lucked out that your adversary did not leave the building because I would not have granted you time in light of your tardiness if he had left.
I appreciate it, Your Honor, and sorry I was several minutes late. I got delayed by the trains and buses. May it please the court, Thomas Chase.
5 minutes.
On behalf of Appellant DKC Group Holdings and Dana Kepner Company, LLC. This appeal concerns the relatively simple issue of the scope of a forum selection clause entered between the parties. The question...
Well, the court in the Supreme Court dismissed this one cause of action for aiding and abetting breach of fiduciary duty. The court said there was lack of personal jurisdiction because you failed to plead a sufficient nexus between the aiding and abetting claim and the confidentiality agreement. So how do you claim that, in fact, you did sufficiently plead this so that we should not dismiss this cause of action?
Sure, Your Honor. Great question. The breach of contract claim that we assert is based almost entirely on the same facts as the aiding and abetting breach of fiduciary duty claim. The facts are almost coextensive. The agreement obviously prohibited defendant from soliciting and hiring plaintiff's employees, and we've made out a well-developed record that they hired 50 employees, including many senior employees, almost immediately in clear violation of the confidentiality agreement.
Sir, was the identity of the employees learned by virtue of the information that was provided under the umbrella of the confidentiality agreement?
In part, based on a meeting that occurred between management and potentially from the due diligence discovery that occurred, they would have learned about some of the employees, as well as many other aspects of the business.
And then there's a claim that some of the people that the company allegedly poached then went back and they poached some more people from the company.
Correct, correct. So the confidentiality agreement and the contract claim is premised on the violation of the restriction that provides the defendant will not solicit directly or indirectly plaintiff's employees. So we believe that claim is clearly established. And the process by which they solicited both directly and indirectly employees in violation of their contractual obligations mirrors almost identically the process by which they aided and abetted the breach of fiduciary duty of our former senior employees who owed fiduciary duties to us, particularly, as we note in the complaint, 3 individuals, Mr. Bill Reno, Mr. Todd Flick, and Mr. Russ Soderquist.
Now, you have a lawsuit pending in Arizona or someplace against these people, right?
We have a lawsuit against the subsidiary of Reese, an entity named Fortaline, correct.
And are these individuals also named in that case?
Those individuals actually have their own agreements that are subject to arbitration provisions. So there's a AAA arbitration proceeding against those 3 individuals. So there's
Arizona and Nevada.
Well, the arbitration provision is subject to a New York venue clause, so that is proceeding before the AAA in New York. The action against Fortaline, which is the subsidiary and also non-signatory of the confidentiality agreement, is in Arizona and Nevada, those 2 states. But our sole jurisdiction against Reese, the parent company that signed the confidentiality, is New York.
Pursuant to the confidentiality agreement.
The confidentiality agreement. So really, we believe the most compelling argument for why our aiding and abetting the breach of fiduciary duty claim is covered by the forum selection clause is because the facts of that claim are almost identical to the facts of our breach of contract claim. We see Mr. Pacifico sit down with Mr. Reno particularly, and they email on the date that Mr. Reno resigns. Mr. Reno sends lists and lists of people that should immediately receive offer letters.
So the forum selection clause that you're referring to in the confidentiality agreement says that New York is the exclusive jurisdiction for any suit, action, or proceeding arising out of or relating to this agreement.
Correct, Your Honor. It uses extremely expansive language, really the most expansive language available to the parties that's ever used in these agreements. Defendant is provided that it hereby irrevocably and unconditionally submits to the exclusive jurisdiction of any state or federal court sitting in New York over, quote, any suit, action, or proceeding arising out of or relating to this agreement.
And that relating to language truly broadens the scope.
In a case like this, certainly. I mean, it doesn't even have to broaden it that much because the facts of the aiding and abetting claim are identical. It's not like some of the cases that are cited by defendants where the confidentiality agreement it covers one scenario, but the related tort is something completely different. The most important sort of exhibits to understand or to consider in this that are attached to the second amended complaint are Exhibit S and T and Q. Particularly, if I can direct you to Exhibit T, we see Mr. Bill Reno. He signs his acceptance agreement, accepting employment, being paid millions of dollars by defendant on the evening of September 9th. On the morning of September 10th, he is already emailing Mr. Pacifico, who's the representative of Fortiline, and one of the signatories and representatives identified in the confidentiality agreement, a list of all the people who should already get offer letters. And he lists the terms, the sign-on bonuses they should be offered, the annual compensation that they should be offered, the guaranteed commissions that they should be offered, and the end-of-the-year bonuses that they should be offered. These packages are basically apparently negotiated and agreed to. So not only do we see obvious solicitation, breach of contract, but we see this very important manager. He was the most senior manager of our operations in our most important market, Arizona, delivering essentially a prepackaged hiring plan to defendants. So that overlap, we submit under the case law and the policy and established law in New York, clearly makes the aiding and abetting breach of fiduciary duty claim covered by the choice of law here.
Thank you.
Good afternoon, Your Honor. So we'd like to briefly respond to Mr. Chase's comments. The forum selection clause exists in a non-disclosure agreement between the parties. That is very clear. It addresses claims that arise from or relate to that. What claimants are trying to bring here are breaches for essentially 4 other agreements, 3 award agreements between them and 3 individuals.
They don't need to do that because the confidentiality agreement says don't steal our employees, right? Don't poach our employees. Why can't we just limit it to the relating to this agreement? Why do we even need to look anywhere else? Or do we need to look anywhere else?
At these other, Your Honor, I would agree. We do not need to look at these other agreements because they are irrelevant. Mr. Chase himself represented before Judge Crane that.
But you're missing the greater point of my colleague, which is you would be in the same position anyway, right?
No, Your Honor, we would not be because they are not overlapping claims as Mr. Chase suggests. We're talking
not what?
Overlapping claims as Mr. Chase suggests. Certainly there may be some similar facts, but we're dealing with 4.
How do they not relate to?
There are 4 entirely separate agreements that we're talking about here. 3 award agreements, which our client is not a party to. They have their own forum selection clauses. They have their own arbitration provisions. They are not present here. We are not parties to them. Likewise, there's an employee handbook that they are claiming that we have somehow created, induced them to violate. These are not agreements that we are party to. They're not even things that we've necessarily seen. We have gone to this point in this litigation without these documents being any part of the litigation, right? We don't have to do them. And when you look at the case law, there's the BMW case that we cite that talks about one of the critical things when you look at bringing extra contractual claims in under a forum selection clause, the critical component is whether or not the claims are dependent, the tort claims are dependent on the contractual claims. Here, as Mr. Chase has said, even if the contract does not exist, the NDA between our parties, he can still bring those aiding and abetting claims, right? So they do not need those agreements. In other words, they are separate and distinct from the contract between our parties. There's no.
So you're arguing that only his former disloyal employees should be held to account for their agreements with the plaintiffs here, and that the only claims that should be brought against your client is any alleged violation of the confidentiality agreement. Is that your argument?
Our argument is that in this forum, Your Honor, this is the forum that the parties agree to for claims that arise from or relate to.
I wish you would answer my question.
I'm trying to. So with respect to the aiding and abetting claims, Your Honor, I'm not suggesting that plaintiffs can't bring them somewhere, but this isn't the right forum. That's why they have sued our subsidiary and the other individuals in other forums. They have brought claims in Nevada and Arizona and recently compelled them to arbitration. They're exactly the same claims without.
So the claims might be viable, just not here, even though the confidentiality agreement has its own forum selection?
That is right, Your Honor, because these claims have to, if you look at the BMW case that we cite, the direct products case. We have, there's a Credit Suisse case that I think is directly on point in our papers. And in that case, you had two parties who actually entered into two successive agreements. The court was very, very clear that, and one had a forum selection clause in New York, the other one did not. The court was very clear that you could not compel the parties for the second contract into New York on the first one because of that forum selection clause.
So was the forum selection clause in that case substantially similar or identical to the one before us?
Per the court, it uses the words arising out of or relating to. We would also refer the court to Phillips v. Audioactive Ltd. 494 F3D 378 Second Circuit 2007, which considered a similar situation where a plaintiff sought to dispute ownership over certain music rights. The parties had entered into an agreement over that music, but because the plaintiff only sued under issues of authorship, not under issues of the contract, the court found that there was not jurisdiction under the forum selection clause, which expressly used language about claims arising out of that agreement.
So there is obviously a cause of action in this case for breach of the confidentiality agreement. There's also a tortious interference cause of action and unfair competition. So all those stay, but the aiding and abetting of breach of fiduciary duty cannot stay.
That is absolutely correct, Your Honor. We're not disputing the jurisdiction over the claims that are, as the case law says, dependent upon the contract, right? That is what the case law says. It's not simply that there is some Venn diagram of overlap of some facts. It is, must you interpret that underlying contract for it to arise out of or relate to that?
Well, in fairness to your friend, I thought the syllogism was we had a relationship, we the parties in this case have a relationship that's reflected in the confidentiality agreement that was designed to allow for due diligence and hopefully facilitate the sale. You learned of one or more of these employees that ultimately were solicited by virtue of that due diligence process. You were prohibited from soliciting those employees for 2 years under this. You solicited them. Therefore, it's the claim for aiding and abetting breach of fiduciary duty on the part of the former employees relates to the confidentiality agreement. And I appreciate that's like 3 more links in a syllogism than are permitted. But
well, I think one of the things that I would say is there are many things that Your Honor said that Mr. Chase said which are not in the record, and we could certainly go through and parse that apart, but I think we would rely on the papers for that. But I would just correct that there is no evidence whatsoever that we learned of a single employee's name in this process. There is one person
So
who...
it's just by coincidence that the day after, you take their top manager and 2 other of their managers, and then later they help feed 50 of the plaintiff's employees into your... That happened by accident, right?
Not a coincidence, and certainly not the day after. So we did this due diligence in 2022. In 2024, nothing happened then. In 2024, they put their company back up on the market. We went to go say, hey, we're interested in this. The day we signed that non-compete, that very same day, they sent out an exclusivity agreement to another company, did not provide us a single document. 7 months, 6 or 7 months later, one of the employees from that company, and this is a very insular community, this is per the testimony, came to one of our employees and said, we really hate this new company we're working under after this acquisition. We'd like to go. Let's be clear. Under this amendment that was filed in 2024, we didn't receive a single document. There are emails in the record that we have submitted.
Does that change the fact that you agreed that for 2 years following the signing of the confidentiality agreement, you agreed not to solicit any of their employees directly or indirectly?
So in 2020... Is
that a yes or no?
Well, I want to make sure, because there's 2 agreements. I just want to make sure. So 2022, I would agree with Your Honor, no, it doesn't. In 2024, we would submit that it does, because we never received any value under that agreement, but that's another...
Right. Thank you.
Just to quickly summarize, we don't think this is a stretch case. In case after case, courts allow or apply a forum selection clause that arises in a contract but refers to claims that relate to the contract to cover related torts. So here we have very related torts. It's not a stretch. It's not an edge case. The torts are based on the same identical nucleus of facts regarding the same parties, and those tort claims are the unfair competition claim, which is in, the tortious interference claim, which remains in, and the aiding and abetting the breach of fiduciary duties that was clearly owed by these senior representatives, which we believe should be in. It should join the other ones. We think it's a very clear.
The duty was owed, but as your friend, I think, would argue, pursuant to a different contract, a different agreement.
Right, there are other facts, but the nucleus there are other, law or legal issues, but the nucleus of events, I mean, when it comes down to trial or trial exhibits, those exhibits S, T, and U, which I referred to, which show, Mr. Reno coming in and saying, here's all the people I already lined up. They should have already submitted their letters of application, and in fact, just send them offer letters today. This is like 12 hours after he accepted his offer letter. It's the morning after. The evening of the 9th, he says he signs and accepts. The morning of the 10th, September 10th, 2024, he's already saying, send out like these 15 letters, offer letters. Everybody should be lined up, and they should have had submitted their applications already. So he obviously had teed up many employees while he's still employed, while he still owes a fiduciary duty to my client. So that's the aiding and abetting we see of Mr. Reno's and Mr. Flick's particularly breach of their fiduciary duty. All of those facts really relate to the soliciting, both directly and indirectly, of those same people. Obviously, defendants directly solicited Mr. Reno and Mr. Flick, and the evidence suggests very clearly that Mr. Reno particularly and Mr. Flick indirectly solicited the employees as well. They used Mr. Reno, Mr. Flick as, you might say, the cat's paw, right? They're inside plaintiff still, and they're going and lining up a lot of the subordinate sales and support staff. So if no further questions, I rest. Thank you.
People versus Elias Ramos. You may proceed.
Good afternoon. May it please the court. My name is Danielle Godwin with the Office of the Appellate Defender for Mr. Elias Ramos. Mr. Ramos asked this court to reverse his gun possession conviction and dismiss his indictment under the Second Amendment of the United States Constitution because the waiver of appeal in this case was invalid and does not preclude the appeal. In New York's gun licensing scheme, in effect at the time of his arrest, was unconstitutional as applied to Mr. Ramos.
We've decided that issue and opined on this Bruin issue, this argument of Second Amendment several times, and there are no additional arguments being raised here that we haven't already disposed of. So why would we change what we have now said at least 50 times?
Mr. Ramos is raising additional arguments, specifically in his as-applied challenge here. He's arguing that, the gun licensing scheme as applied to him at his arrest precluded him from exercising his Second Amendment rights wholly because he was indigent. At the time he was arrested, Mr. Ramos was unemployed. He was a young father. He was living with his mother, with his son at the time. He got a gun for the same reason that many New Yorkers would get a gun, to protect himself and to protect his family.
Do you need to show somehow that the fee itself was exorbitant or it was designed to prevent gun ownership, or is it just sufficient to say that he was indigent, he couldn't apply?
It's sufficient to say that as applied to Mr. Ramos in this specific case, it was unconstitutional for him. He could not afford the almost $500 fees at the time. He was indigent, he had no job. He had not had stable employment pretty much his entire life at this point. This is different than Mr. Johnson, who's not raising anything, about fees specifically here. We're not saying that, fees typically cannot be, constitutional for a New Yorker, but as applied to Mr. Ramos in this case, someone who couldn't afford them, had no opportunity to waive them at all or to, avoid them. He was required to, in order to apply for a license, pay these fees, and he could not. He was indigent, again, and a young individual. This is his first time taking a plea deal, his first time even considering anything of this magnitude, and he just wants the opportunity.
Is that a claim that's as applied just to him, though? I mean, in terms of the fee itself? right?
In other words, there are other New Yorkers that can say the same thing. So do we open the door now to anybody who says, I can't afford the application fee, so take my application?
Not to any New Yorker, but to a New Yorker like Mr. Ramos, who has a preserved as-applied claim here. He preserved this in his initial motion to dismiss in the
No, but
lower
my
court.
question is, if we follow your argument and issue a decision that says that, then the impact of that is that New York City then has to accept applications from anyone who says I'm indigent.
If that could be it. I mean, somebody like Mr. Ramos who couldn't afford it, unfortunately, here it's actually the government's burden to show that there's actually any real interest in showing that there's a...
And just point me, can you, and this is not this question is just in general. In the record, does he need to show indigency prior to applying, that maybe was rejected, or not that it was rejected because he wouldn't have applied, but does he need to show that indigency at any point other than on this appeal?
No, he did not. It's the government's burden here to show, under Bruin, to demonstrate that the regulation, in this case, application fees, are consistent with this nation's history and traditions.
Well, see, then that brings the point, that brings the point as to the as applied to him argument, right? Because if it's as applied to him, we need something more about him. If it's just something that you're showing that it's an exorbitant fee or anything of that nature, then would you need something more?
No, not necessarily. This is, I mean, we're talking about somebody's fundamental rights to possess a gun under the Second Amendment. This is something that cannot just be restricted arbitrarily. There needs to be concrete reasons. The government needs to show a legitimate reason to restrict somebody from possessing a gun just because they're indigent, just because they can't afford the fees.
So to Judge Manzanet-Daniels' point earlier about the concerns about the proliferation of Bruin-type claims, so you make a Bruin motion, we'll call it, before the trial court, so that'll satisfy preservation. What do you have to do in moving to dismiss one or more charges that are premised on a gun possession to then foist the burden on to the people to come back and justify the regulation as satisfying traditional notions of the language of Bruin, the historical traditional notions of gun regulation?
Ultimately, it's the government's burden to show that. When they show that, I mean, here they have not argued it in their opposition to the original motion to dismiss. They haven't raised it in their brief here, anything about history or traditions, restricting somebody from owning a gun just because they're indigent. But anybody who is indigent who's preserving this under Bruin...
That's the way you're framing it, but that's not the only reason why this happened, right? He didn't get prosecuted because he was indigent. He got prosecuted because he possessed a gun without a license.
That's correct.
To be clear, but you'll have time on.
Okay.
You want another
I
question?
mean, well, I just have one more. So would it be enough in your scenario that you come in, you make the motion before the trial court to dismiss under Bruin and say, my client is indigent, and there doesn't have to be a factual support for that. Making that argument is enough now to put the burden on the people to come in and justify the regulation?
Well, here I'll say there is factual support. He did raise this in his motion to dismiss, page 4, paragraph 6. So this is a preserved claim. It has to be preserved. We know that. He's preserved it here, Mr. Ramos. And I can finish up on rebuttal. Thank you.
Good afternoon. Maria Wager for Respondent. As Your Honor pointed out, I won't spend time on the facial challenge. This court, as well as the Court of Appeals, has already addressed those issues. But as to the fee, I disagree that this issue is preserved. Defendant did bring up that his counsel did state he was indigent and unable to pay the fee, but he only argued that as to standing, he was making a futility argument. It would have been futile for me to apply because I couldn't pay the fees. He never challenged the constitutionality of the fee provision in the statute. So that's why the people didn't address it. It was never raised.
By your lights, would it be sufficient for, and I acknowledge that isn't this case, but if a defendant were to make a motion to dismiss under Bruin before the trial court and say, I'm indigent, and therefore it imposes an unconstitutional burden under Bruin, would they have to support that factually, that indigency, or at that point, would that be enough now to put the burden on you to demonstrate a regulation of that, the regulation survives constitutional challenge?
I would say that there has to be some factual support, otherwise it's just a conclusory statement. Here, it was a simple sentence by counsel that defendant was indigent. At the very least, there should have been a sworn allegation of facts from the defendant. We frequently see affidavits from defendant.
But whose position would it be to show that the fee itself was exorbitant? Or is it just that we, as the state, can set the fee and then you have to show something else?
I don't think it's a matter of showing exorbitant or not. I think with a fee, if the statute is otherwise valid, right, a state can exercise its power to impose a fee, and the fee has to be related to show that it's a proper, to run the program, for example. So if the government can show these fees are necessary for the whole application structure, a background check, fingerprinting, to cover that. It's not to make a profit. So I guess that would be showing it's not exorbitant. It's actually
Maintain those records, because once you issue a license, you have to keep the record of that license and renewals, et cetera.
right, and that's not free. And there is a case from the New York Court of Appeals that economic hardship is no argument against the constitutional validity of an otherwise valid exercise of the state's power. So, even if it was preserved, I also want to point out, my colleague concedes that this is a facial challenge. So therefore, the waiver, it was dicta in Johnson, but this court has held that, such a as-applied constitutional challenge, you have to show standing, and it can be bargained away with an appeal waiver, and this appeal waiver is valid. The last thing I want to say is defendant cannot show that but for the proper cause provision and the fee provision, he would have been granted a license. He not only possessed the gun, he fired that gun several times. It was defaced. There is no lawful right to possess a defaced gun. There is no such license. He possessed that and fired it while he had drugs on him, which were packaged for sale, and he had a criminal record. So I don't think this was his first plea. He has a conviction for identity theft, and he had his probation revoked for a robbery case, although the disposition of that, what that exactly was unclear. So he would not have been issued a license but for these provisions in any event.
Thank you.
Thank you. Just a few quick points on rebuttal. First, we are not conceding that this is just a facial challenge. We are arguing that there is an as-applied challenge here, as I discussed earlier. Secondly,
But if it was an as-applied challenge, would it be barred by the waiver?
not necessarily, but the waiver here is invalid for many of the same reasons that this case is.
If we don't hold that, where do you stand? If we think the waiver is fine under the totality of circumstances pursuant to People v. Thomas, where does that place you?
Even if if you find the waiver of appeal valid, we find that given the fundamental nature of these rights, of the Second Amendment rights here, that you should still find in favor of Mr. Ramos in the interest of justice. Again, there are no facts on the record that he ever fired a gun in this case, just that he possessed a gun. This as-applied argument is a preserved claim. Again,
The police officer said he overheard shots. That's what brought him to the defendant.
yes, Your Honor, he overheard shots but never saw anybody fire the shots, especially not Mr. Ramos.
Okay,
Thank you. Thank you.
Jones Law Firm versus J Synergy.
Good afternoon, Your Honors. Angela Lee of Schlamstone and Dolan for the appellants Jones Law Firm and Tanner Jones. This is an appeal from a pre-answer motion to dismiss. We maintain that the trial court erred in failing to dismiss respondent's 6 counterclaims, each and every one of which is facially deficient as pled. Most importantly, none of the counterclaims properly plead damages.
Why aren't there damages from the PAM action? the action, the Article 75. Legal fees that were paid there.
So those are actually provided for in the retainer agreement in the fee shifting provision between the parties, which is not one of the counterclaims here. But even assuming that is part of the damages, it is not sufficiently pled in the counterclaims as the pleading stands.
Why not? Why isn't it sufficient?
Well, it depends on which counterclaim you're referring to, Your Honor.
All of them.
Well, again, the costs are provided for under the fee shifting provision in the retainer agreement.
So that means that because there are costs provided for in a retainer agreement, you can initiate unnecessary litigation?
No, Your Honor, that is not what we're saying.
And in the event that unnecessary litigation is indeed pursued, that a court holds, wouldn't that be a damage? If I have to pay for a lawyer that I would not have otherwise had to pay for, but for that improper litigation? Why is that not a damage?
Well, as the pleading stands, it is not, well, I'll revert back to the retainer agreement provides for that. And so appellants have submitted in the record that to the extent that that is one of the damages that are sought, that may be a valid claim under the retainer agreement, but it is not a valid claim for damages under the counterclaims as pled.
Why? Why isn't it valid under the judiciary law, for instance?
So the judiciary law is a statute that is meant to be interpreted very narrowly, and the underlying fees, respondents claim that the underlying fees are reasonably inferable damages, but in all the cases cited where attorney's fees were rewarded, the facts are different than the case here. There are cases where a party affirmatively made false representations to a court during the course of a proceeding, of a court proceeding. That is not the case here.
Yeah.
Oh, okay. 3 of the counterclaims are under judiciary law 487. None of them adequately meet the elements. First of all, the claims pertain to a whole continuum, I'll use my friend's word in his opposition brief, a continuum of behavior, most of which has nothing to do with an action pending in court. So first, it's the retainer agreement, which failed to disclose the relationship relating to Pam and Mr. Jones.
And the arbitrator.
But the Court of Appeals has held that 487 does not apply to conduct predating or postdating a court proceeding.
But when the petition was brought to confirm this arbitration award, that was from what I believe the record shows, before an arbitrator that had ties to your firm, before an arbitration body that was organized by your firm. And so when that petition to confirm that arbitration award it has to go through, and now we're here, why aren't the legal fees there subject to 487?
So the petition that was filed in the confirmation proceeding itself did not contain any material misrepresentations. And when it was brought to light, the relationship, my clients were...
Counsel, the arbitrator represented the plaintiff in prior actions, and the plaintiff represented the arbitrator in prior actions. And they didn't know this, and they went to arbitration. And Pam was owned and created by this person. So isn't that a little bit much to then go file a petition to confirm the award?
Well, Your Honor, we're certainly not disputing that mistakes were made and stupid ones.
Is it
Mistakes on behalf of an attorney? An attorney that went to law school? This was a mistake?
Yes, Your Honor, it was indeed a mistake.
A mistake to disclose. I own the arbitration, and I know the arbitrator. I represented him in court, and he represented me. It was a mistake.
I read that language in the briefs. We concede mistakes were made. And I mean, I just couldn't even believe that that was written in there in that way.
Well,
You don't have to answer to that. I just wanted
that
to
is
say
how it is
that.
written, Your Honor, and that is what it was. It was a mistake. However, being stupid and making mistakes does not elevate a claim to fraud.
Because he forgot? He forgot
he
that
owned
they
it.
represented each other? They forgot?
And he forgot that he owned Pam. He forgot that too.
I'm really trying to understand how the firm can come into this court and with a straight face make that argument. But you're gonna have time on rebuttal because you have 3 seconds.
Well, Your Honor, we did not say that we forgot. It was an omission that was a mistake and was later disclosed to the court in the petition hearing.
Yeah, you're gonna disclose it a whole lot more than that.
Hey, please, the court. My name is Judah Cohn, and I represent the respondents.
Counsel, mistakes were made. What are we going to do about it?
I think that there's an...
I mean, that's their position.
I understand that that's their position, and their position is also that they were completely forthright with the petition court. That's not true. That's not true in any way, shape, or form. In the petition action, if it wasn't for the discovery of this scheme from the get-go that was a continuum, as I wrote in my brief, all the way through the courts, stamping its imprimatur, not just in one case, but in multiple cases, and even the lower court judge is one who gave them, with the same arbitrator, a confirmed arbitration. But more than that, if they weren't caught, they would never have said anything, and they doubled
Counsel,
down in the
I was gonna ask you, so she moved to, or her client moved to confirm the arbitration award, which was obtained from a company with all these connections. You moved to vacate the award, correct? This was a special proceeding, just, confirm an arbitration award in Article 75. The judge wrote very little in that decision. He said, I'm going to vacate the award because of what has come up, and the rest of the petition I'm not going to deal with because that's not appropriate for a special proceeding. Go ahead and bring a plenary action, which is what's before us now.
That is correct, Your Honor. In the prior appeal, we appealed. We appealed because we felt that the lower court judge had not gone far enough, and he sua sponte dismissed all of the Judiciary 487 claims, the ethical violations, and we also requested...
Has there been an ethical complaint filed?
No, we didn't do it. And I'm not recommending to the client to actually go ahead and do that, and I don't know whether that's my per se responsibility, but I did ask the court in the petition action that it was their judicial responsibility under a specific section that there was a referral.
We are very familiar with that.
At oral argument, Judge Frank mused to himself during the petition and the cross petition to vacate the award. Maybe I should go and head to the Attorney General's office. And then, the next day, after he dismisses the case, well, we're thinking on a certain level, okay, it's all over. Let it go. They turn around, they reinterpret Judge Frank's decision as the stamp of approval to go ahead and bring a breach of contract action for attorney's fees. Now, if they have an admitted conflict of interest, admitted throughout their papers constantly, then the result of an admitted conflict of interest is an automatic forfeiture of attorney's fees.
Well, can I ask you, so this case, I mean, this appeal is that Judge
Frank.
Social Judge
Same
Frank.
judge.
Yeah, Judge Frank did not, she thinks that Judge Frank should have dismissed all the counterclaims, which he did not. So on the judiciary law, there are 3 counterclaims, I believe. Counsel, your adversary said these judiciary law claims have to arise out of some kind of court action, some kind of fraud on the court or whatever, and this did not. Can you address that on the judiciary law claims?
Yes, Your Honor. Our position is that not just from the inception of the case with the signing of the retainer agreement, not just with this Wyoming corporation to hide PAMs and their ownership interest and whatnot, but rather when they walk into court to get the court's stamp of approval on their nefarious, deceitful, collusive scheme, that's what triggers our right in order to go after them under Judiciary Law 487 sanctions. And this is a continuum. It's not a discrete event, but rather when they move into court to confirm the award, that's when we get triggered to allow it. If they never had gone forward to confirm this award, we really wouldn't have been the wiser. And either with the multiple other cases in which the same arbitrator, in which the same firm has gone into court on numerous occasions to confirm this particular collusive, deceitful scheme in Wyoming that is brought here to New York. Your Honors, otherwise I rest on my brief. Thank you for your time.
Thank you. You have 1 minute.
Counsel's outrage does not change the fact that under 487, any conduct before or after an actual court proceeding is not contemplated by the statute. As I said prior, there are certainly—
So your position is that the alleged deceitful conduct occurred during arbitration and not by filing the petition and coming into court to confirm that arbitration? They're two different things?
Correct. Every allegation is a separate, discrete event. So the only thing that would fall within the purview of 47 is filing of the petition. That by itself—
and confirming an award that your clients knew was gained improperly that's okay.
That's not—
That doesn't run afoul of don't deceive the court.
Well, the statute is clear that it requires a court proceeding as well as an intent to deceive. Here,
I think we got those both covered.
Well, on
both of them. You filed an order to confirm in a court, and you deceived. So I think they're both covered, but we've heard your arguments. Thank you.
Thank you, Your Honor.
Hagen versus Robertson. You may proceed.
Good afternoon, Your Honors. I'm Reed Aronson, Aronson, Maskey, and Sloan. I'm counsel for the appellant, Cindy O'Hagan. This case should be about a straightforward reading and application of the language of the party settlement agreement. Respondent, by his own admission, did not comply with the joint custody or the default provisions of the party settlement agreement. He did not properly consult with appellant regarding the expenses for which he ultimately sought reimbursement, and he, by his own admission, never sent proper notice regarding any of the alleged defaults, and no notice whatsoever regarding the vast majority of those alleged defaults. Despite getting tens of thousands of dollars in support each month, he felt that he had no obligation either to consult with appellant or, if he did not, to pay for the costs that he unilaterally incurred. The order below should be reversed for 4 primary reasons. First, the motion court improperly severed the agreement's joint decision-making provision from its financial consequences. Under the motion court's logic, the joint decision-making provision was mere surplusage, as neither the motion court nor respondent have proposed a meaningful mechanism for enforcing it. Second, the court excused respondent's breach of the contract's express notice and opportunity to cure provisions. That is a threshold contractual failure.
And
Now-
that was asked to some of the items, right?
Oh,
Because
the
there
ve-
were-
I see-
let me finish my sentence.
I apologize.
Okay.
Little-
So, we're all a little
Little jumpy.
excited. It's okay. So there were some things that notice was given for, and admittedly, there were several items that specifically weren't detailed in the notice that was sent, correct?
Justice Daniels, I would say there was not proper notice as to any of the items
Right.
for which default was sought, and as to whether there was any notice
Because
whatsoever.
the certified mailing didn't.
There was no certified mailing as to approximately $8,000, but as to the vast majority, approximately $17,000 of the add-ons, or the alleged
But the
insurance.
add-ons were things that by the agreement, your client was responsible for, the tutoring, correct? That by the agreement, she had to pay for 100%.
Under the agreement,
Okay? And the agreement did not require that she agree to who gave that tutoring and said that she should be consulted.
Your Honor, it doesn't say that. However, inherent in the concept of joint decision-making is responsibility on the part of a party who wants to get reimbursement to involve the other party
Right,
in
and
making
indeed,
decisions.
the wife was one of, indeed, by her own request. The father put the children in the ACT, SAT tutoring, correct? And she wanted that.
She did
right?
want.
And he didn't, she, admittedly, he says, I didn't consult her. I used the same one I used for the older daughter, and it cost less than what she recommended. So what's the problem?
I'm not sure, Your Honor, that it says in that it costs less. I believe that it costs more. It is, in fact, the tutoring company that she suggested, but there was no consultation with respect to that in particular. There was no
He had to
consultation.
come back. So after she told him, enroll the kids because they're not, the girls aren't living up to their potential, I believe was her phrase, he does exactly what she says, and now she's griping that he didn't come back to say, I'm going to go with this one. Is that okay with you?
Your Honor, yes, I believe that is what he should have done.
And is that what the order says he has to do?
The order says consultation.
Consult. It doesn't say I have to get your agreement before I hire someone.
And I would suggest, Your Honor,
We
that
beat this one to death. How about we go on to the next thing that your client is complaining about?
well, and I would point out also, Your Honor, that with respect to the camp, there was no consultation whatsoever. There was
But
no.
that also was something that she had to pay for under the agreement.
She has to pay for camp if there's an agreement, but again, under the prospect, and I'll answer your question, under the prospect of the motion court's logic, he could have signed them up for a $150,000 summer camp in Switzerland, and she would have absolutely no recourse but to pay.
And I think you would have had a much better argument if he had done that to complain about that. But I'll hear you on the other issues when we get back, okay? All right, counsel.
Good afternoon, Your Honors. May it please the court. Shannon Simpson for respondent Christopher Robertson.
So counsel is correct that the notices were not completed as per the agreement. There was no certified mailing, and not all of the notices were indeed received specifically as to each of the items. So what do we do with that?
That is correct. The court below found that the provisions were complied with, that the notice provisions were complied with, notwithstanding the lack of strict compliance with the form requirements. And there are two pieces here, as Your Honor may have mentioned before, one related to the tutoring and one related to the summer camp. The motion itself followed 4 months of non-payment of child support at a time when Ms. O'Hagan was not represented. And we would engage in email correspondence with her. And when the default notices—
Now, Ms. O'Hagan is an attorney herself.
She is an attorney herself, one of the most sophisticated litigants you can imagine, as represented to the trial court. She said, don't waste your money on FedEx, the email is fine. So email notice goes for a portion, but not all, admittedly. The remainder of the provisions of the default with respect to the remaining fees for tutoring and the summer camp were included in our motion. And as the court noted, she had actual notice and a time to cure. And he cites, the court below, as well as our brief, cites those cases holding that strict compliance with notice provisions of default is not required in a contract, provided that the person receiving the notice receives actual notice and is not prejudiced.
Unless
I'm sorry.
Unless the notice is a condition precedent, because a substantial compliance with a condition precedent isn't sufficient. And here I thought the default provision used one of the hallmark phrases, if and only if.
It doesn't.
And it refers to the notice provision, including the methods of notice.
It does, one of which was waived. Don't send me the FedEx, email is fine. The other of which is waived, in my view, by Ms. O'Hagan's conduct. Ms. O'Hagan brought a cross motion alleging her husband had defaulted under the agreement. This is the cross motion you may have seen in our papers. It was referred to as silly, cheeky. It wasn't withdrawn. We had to respond to it, and the judge had to render a decision on it. She filed that motion to hold her husband in default, of the former husband in default, without serving him a notice of default. She provided notice of his default in her cross motion, the exact same thing that Mr. Robertson did by way of his motion to recover the fees for the tutoring in the summer camp.
Counsel, I have a question about the attorney's fees. He's seeking $25,000 in reimbursement and gets $35,000 in attorney's fees? Explain that to me.
I will, and I think the court, it's exactly the question that the court started with in the argument below. The motion, and I think it's important to understand the context, which we've included in the brief. The motion followed months and months of defaults, many of which were cured before the motion was actually brought. It followed 4 months of a refusal to pay child support. It followed text messages to the party's twin daughters from the mother that she wasn't going to pay their college tuition. It followed threats that the mother would reopen the settlement agreement, sell the apartment where the girls were living, and end support. It followed threats that said, I hope you die homeless on the streets. You and our children should.
How does that relate to the attorney's fees, though?
Because the reason to bring the motion, as opposed, was in this context. And by the time we got to the motion, this is what was left.
Counsel, but what you're saying, look, in matrimonial cases, it is like the stamp of the case that it's acrimonious. It is rare that parties who are getting a divorce or in the midst of fighting over child support, et cetera, that everybody's lovey-dovey and happy with each other. So that there's acrimony, that's part and parcel of matrimonial practice. And what I'm hearing you say is, since we had all that trouble with her for months, I added everything I had to do over the 4 months leading up to. How is that correct?
So that's not correct. These are the fees that were incurred in connection with this
22
motion.
hours to prepare a default motion?
Yes, and respond to the
22 hours?
and respond to the cross motion that was filed as well. And to
That sounds excessive to me. 22 hours for a default motion?
a default motion and a response to the cross motion, Your Honor. And the court below did not find that the fees were excessive.
Obviously, but we're here.
Correct, Your Honor. I would also like to add that in particular with respect to this notion of joint custody, and you'll see this in our brief, there was an ellipsis used to excise language from the Conroy decision, which I think expressly and specifically distinguishes that case from the case at bar, and I would just recommend to the court to review that case in particular. I think it is particularly misleading, the language that was removed from that case.
Thank you.
Thank you, Your Honor. First, with respect to a point that counsel made, there was no waiver with respect to the notice, with respect to the only time that any of the defaults were noticed. There was an email about the basic support. You don't need to send that via FedEx. And then later, there was another email. And that, again, related only, even that one, which was never waived, related only to $8,500 approximately of the SAT tutoring costs, not the rest of them, which were never notified. And on page 37 of respondent's brief, they admit the notice was given in the context of the enforcement motion.
Did you want to comment at all on the attorney's fees that were granted?
Yes, and whether they're excessive or not, I do think that it's a lot. I think that, you know, what the proved amount
means excessive.
I thought
I would never want to imply that about a co-counsel.
I thought that they asked for less. I mean, they got
asked
more
for-
than they asked for.
They asked, well, in the first appearance, they said or in the first brief, they said we expect that it will be as much as $15,000 or $16,000, and then suddenly at oral argument, it was 36. The court went through and said, oh, it's 35 and a little bit. Then after their declaratory judgment request, which, as you hear, this was about the threats. That took up a huge portion of their motion. The court only deleted $154 from the $35,154 that were stated on their invoices. So, and if you look at the billing rates, that's less than 10 minutes of counsel's time. I don't see how they could have made that argument. Again, you read the brief, or you read their briefs, both here and in the court below. So much of it is focused on basically saying, as Your Honor said, this is a very acrimonious situation. She's a bad guy. And ultimately, that's not the purpose of a default provision. The purpose of a default provision is not punishment. It's to ensure that people follow the rules. Thank you.
Thank you. People v. Davon Jones.
Good afternoon, Your Honors. Elizabeth Batkin from the Legal Aid Society for Mr. Davon Jones. We're asking this court to grant a modest sentence reduction of Mr. Jones's prison term by running the 2 terms concurrent, or else reducing his sentence on the second offense by 6 months.
Wouldn't the post-release supervision, wouldn't that automatically be run concurrent? I mean, do we as the court need to do anything?
By operation of law, that is concurrent.
By operation of law, it's concurrent, and the people did concede, so perhaps it could just be a sentence confirming your understanding that it needs to run concurrent, would be sufficient. But as for the reduction of the prison term, Mr. Jones has spent almost his entire adulthood behind bars. He committed his first offense when he was only 22 years old, having recently finished a 3-year prison sentence for robbery that began when he was 18 years old. This court has the power to give Mr. Jones back the last few months that he has in his 20s so that he can get his life back on track. He has a 4-year-old daughter who's visited him in prison. He has a partner. He was working as
That daughter was alive when he committed this crime and the other crimes. So that didn't stop him and did not serve as an impetus for him to fly straight.
The difference...
So why would we do that based on the record of this young man?
The difference is that Mr. Jones has now spent almost 4 years in prison, and the question is really whether the additional several months that he has will make a significant difference to his punishment. Our contention is that an additional 7 years really won't change the degree of his punishment, but what it could do is that an extra several months of freedom could have a significant impact on allowing Mr. Jones to get his life back on track before his 30th birthday. And I would like to briefly touch on the appeal waiver because I imagine my opponent will touch on it. So the court's colloquy was highly misleading, or at best highly confusing, specifically in its discussion of the trial rights Mr. Jones was waiving through his guilty plea. The court told him that just by pleading guilty, he was giving up his right to a hearing to contest his seizure. Of course, Mr. Jones...
Did the court then go on to correct itself and say, oh, well, the hearings have happened, and then continue on?
The court said, oh, well, the hearings have happened, but the court didn't clarify that it had made a misstatement or really the impact of its misstatement. And actually, I would say that the attempts to clarify really only further confuse things. So the court introduced the suppression issue in the context of the rights automatically waived, then said, oh, well, actually, sorry, that's the appeal waiver, then went back to the trial rights, then went back to the appeal waiver. And ensuring that a defendant understands the difference between those rights automatically pled and those rights pled upon an appeal waiver is really one of the most fundamental obligations of a plea court at a colloquy, and the court failed in that responsibility. The court also never properly defined the nature of an appeal, suggesting that it was only the right to have a case dismissed or remanded or to review claims of error, which meant that Mr. Jones was never informed that he would have had the right to challenge his sentence as excessive, even if it was illegal. So we are asking this court to modestly reduce Mr. Jones's sentence.
Thank you.
Good afternoon, Your Honor. It's Joseph Tucker for the respondent. I will address the appeal waiver. I think that, in totality, again, this fits Thomas, People v. Thomas. The court made one mistake, and the court corrected that mistake. He said, as I'll address, when he was discussing the rights forfeited by pleading guilty, he did address, the denial of the suppression hearing. But then he said, we'll address that later. And then later, when he was distinguishing, and he said separate and distinct rights forfeited by pleading guilty as those waived in appeal. When he was addressing the appeal waiver, he said, as I discussed earlier. He then directed him to the written waiver, which, again, distinguished them as being separate and distinct, and was very detailed. So I would argue that, you know, in light of the totality of the circumstances, this was a valid appeal waiver, which foreclosed both the other claims. I won't address the suppression issues since that wasn't addressed here, and I would just say that, you know, this defendant was given a very nice deal. He pled to the minimum on both the criminal possession of a weapon and the attempted criminal possession of a weapon. He had 3 prior convictions. He was convicted as, he was afforded opportunities by the court as a youthful offender, and that didn't do him any good. I mean, he was found in a car with 3 guns. On this conviction that we're dealing with here, and two and a half years later, he was seen on videotape exiting his car, taking a handgun and shooting to a bunch of people standing on the street. I can't imagine how this sentence is unduly harsh, and I'll rest on my brief, and I will sit down this time and allow counsel to.
Thank you. I'm going to give you his extra 15 seconds.
Thank you, Your Honor. First of all, these were Mr. Jones's first adult convictions, and the fact that he was sentenced as a YO really wasn't a gift from the court, given that he spent 3 years in prison at the age of 18. As for the appeal waiver, a more correct express correction was needed, given the confusing implication of what the court had said. The court never specifically told Mr. Jones that, in fact, without the appeal waiver, he would have had the right to challenge his seizure on appeal. And the written waiver doesn't cure things. First of all, on its own, it can't save a misleading colloquy. But second of all, the court never confirmed that he read or understood it or discussed it with his attorney. And in any event, Mr. Jones was left with these 2 different explanations, one that the court had given him, one that the written waiver had given him, and he, unlike we, did not have the benefit of lots of experience with appeal waivers, so wasn't sure, presumably, or we can't be sure that he understood which to credit. So the appeal waiver was invalid and doesn't bar this court from granting the modest relief being sought, which is just several months of freedom for a man about to turn 30 who has spent almost his entire adulthood behind bars. Thank you, Your Honors.
Georgia Malone and Company versus E&M Associates.
Good afternoon, Your Honors. May it please the court. Letitia Thompson, Morrison Cohen for 9 of the appellants. The LL Manhattanville, AZG Manhattanville appellants. This action that was before the court has been long and hard fought, coming twice before this very court on prior appeals. And when the parties finally appeared for their day in court and for their trial, they were entitled to a fair trial where the jury heard the evidence and rendered a verdict on the causes of action to be tried. But that didn't occur here. The trial court...
The charge to the jury contained one question?
One question. And that question didn't reach any of the elements of a claim for a breach of contract, including who were the purchasers, whether there was performance under the contract, what were the damages. None of these were presented to the jury.
Were requests to charge made for those? I read some of the transcript where you were at the charge conference, but those things were requested, and the judge denied your request to charge the elements of a breach of contract as well as damages, which was an issue too.
Yes, absolutely. And I think that begins at page 82225 of the record. There was a long colloquy between me and the judge where I'm repeatedly making those requests that there's actually a full charge to the jury, and that the actual cause of action and all the elements are provided in a charge to the jury, and that there is a jury verdict form that reflects the causes of action.
Now, I know that in your briefs you argued a lot about not being permitted to bring in any testimony from the Galanter case, which I know about what that was, but can you talk about why you should have been able to bring that in, if for nothing else, for impeachment, which the judge said she was going to allow, and then I think did not. These were documents that were marked for identification, I guess, but never got into evidence.
Yes, Your Honor. The Galanter documents or the Galanter admissions were very important because they supported not only our defenses, affirmative defenses in the case, but also counterclaims, right? If Miss Malone or Georgia Malone acted as a broker on both sides of the transaction, she would be prohibited from gaining any fee from the defendants or the appellants in this case. But when this issue was previously before the court, one of the issues was Miss Malone's statements so contrary that they became perjurious, or did they just undermine her testimony and basically admitted that she was on both sides of the transaction? This court previously ruled, look, we're not going to say it's perjurious, right? We're not going to take it that far. We are going to say that you can't go into court and say that this didn't happen and that you didn't make these statements, and sent us on for our trial.
But we did say there was a tribal issue of fact.
You absolutely did say it was a tribal issue of fact. And the Supreme Court underneath first said it was a tribal issue of fact. It came back to you guys. You guys affirmed it was a tribal issue of fact. And then we took it for our day in court, and the presiding judge said, nope, there's no tribal issue of fact here. And in fact, you're precluded from even mentioning it. And that really hamstrung and made it very difficult for the defendants to make any of their case. The jury was precluded from even deciding the very issue that was at the heart. And
one of the things your adversary argues is that the Galanter documents were outside of the record and they shouldn't have been before the court. But wouldn't we at least be able, or shouldn't everybody at least be able to take judicial notice of what our decision says, where it says that it was a tribal issue of fact?
Well, that, and how does this court decide whether that ruling was correct unless we have the material?
100%. Both Justices Pittenberg and Manzanet. And that was the very argument that was made and kind of shot down, right? That we presented it to the court said that she wouldn't consider it. And then when we brought it to you and said, hey, we brought this before the court, we marked it for identification. The appellants then submitted in opposition to their motion in limine saying, hey, you have to consider it. The court, the first department said you have to consider it. And the prior Supreme Court judge said you have to consider it. And we're told, no, we're not considering at the trial level. And then counsel for the respondent says to the court that it's debors the record, which obviously the court excluded it, right? If the court would have admitted it, then we wouldn't have grounds for our appeal.
Clearly, since you attempted to introduce it into evidence and marked it at the trial, it certainly is appropriate for this court to review and consider on this appeal.
Yes, and I did.
So arguments by your adversary that we should not look at it fly in the face of this court's jurisdiction on an appeal.
100%. And interestingly, our opposing counsel sought to sanction us for the conduct of raising this as a matter of appeal, which we in itself thought was problematic, but generally we just don't bring sanction motions against opposing counsel in the same manner that some people choose to bring them against us. Additional errors that the trial court made was when it declined to charge on authority. Right, as we know here, the biggest issue in this case was you had this brokerage agreement, and it was unclear on who was bound by it because there were only two signatories. There was Georgia Malone, and there was Michael
Langer.
Michael Langer. I love that you guys.
We read it.
There was Michael Langer, who signed on behalf of E&M Associates. None of the other defendants were signatories. So one of the questions that
but of course, we know about the line under his name typed in small print that said signatories each have apparent and actual authority to bind all employees, officers, successors, assigns, and agents of all the related entities and affiliates to this letter agreement.
Correct, but Mr. Langer could not give himself that authority, right? No more so than like the secretary at my firm could bind me to something, right? actually there had to be actual authority or apparent authority to sign for someone else. You just can't sign the contract. And this
Signing for someone else other than his father.
other than his father and E&M Associates, who, he set it on the table. So because none of the appellants that I represent were signatories, we repeatedly asked for a charge on authority. And we said it over again and over again. We were told, no, we could not get that charge. There would be no authority. And in fact, the judge in several rulings from the bench prohibit us from even contesting that the authority was an issue. And
You're out of time, but you'll have time on rebuttal, okay?
thank you, Your Honor.
All right.
Good afternoon. My name is David Schlansky, and I represent the Langer defendants. I won't read their names. There's dozens of limited liability companies.
E&M and Langer, got it.
And thank you, Your Honors, for reading the briefs and reading the case file. There's a lot to say here, but I'm going to try to focus on the key things. So the first thing is, when you ask about authority, this is a really confounded case, and some of the things, after years and years, are buried in the record. But in our reply brief on behalf of the Langer defendants, on page 18 at footnote 7, there's this point that's resonant with what Your Honor is asking, which is, prior to commencement of trial, the trial court held that, quote, defendants are precluded from asserting at trial that the E&M non-circumvent confidentiality commission agreement, which is the commission agreement in question here, dated August 30, 2012, signed by Michael Langer, was not authorized. So what ultimately went to the jury was a question of intent about authority and whether those entities tacked on to responsibility for this thing. But that's exactly what the jury was precluded from hearing, and we were precluded from talking to the jury about. So what ultimately went to the jury was a question about intent when we had been told before the trial started, we can't talk about intent. And I know this is not lost on Your Honors, but we live in a country of laws where there's due process. If you're charged with something, even in a civil matter, you get to have a jury, in a case where there's a jury, decide whether or not you did it. They have to find the elements. So the menu that goes to the jury has to have the elements. Now, it's, in our view, totally unfair that this person who got paid on the other side of the deal, as a matter of fact, the jury cannot hear about the fact that she's sitting on both sides of the transaction. And on top of that—
And that would be okay, so long as there's disclosure.
Well, disclosure and assent. There has to be acceptance. So it's not just disclosure, it's proceeding with that knowledge. And in this case, Your Honor, that's exactly right. That did not happen. But the confounding aspect of this is not the facts as they took place in Manhattan, but the facts as they took place in Lower Manhattan in this courtroom, which is none of this went before the jury. It basically is a non sequitur. The jury could have been asked, what would you like for lunch? Because that's what intent had to do with the elements of a breach of contract. It's just, it's an unfortunate circumstance that creates a lot of waste, especially on a case that's gone on this long, that's taken your time, that's taken your resources, and ultimately really needs to be put to bed. And so and I know this is not in the record, but there are other cases that have been brought. Justice Bannon is in the commercial division now. Those other cases have been assigned to Justice Kim in 80 Center. And if Your Honors were to ask, what should you do with this? My view is you should reverse and you should remand. And this should all be before one justice to figure out what's going on with this mess and figure it out in a manner that accords with due process and common sense. You just can't have a jury being asked things that are irrelevant to the charge. Thank you.
Lord Castro for the respondent. My adversary said a lot, but give me some time just to explain what actually happened. This is the third appeal.
We know.
This court made determinations in the first two appeals. And I think we can all agree that determinations of this court constitute law of the case and bind the Supreme Court. Now, let's get to the issue of authority. Michael Langer signed the agreement on behalf of E&M. In 2018, this court made very important findings. Your Honor, in 2018, this court...
Remember that I was on that case, but more important is the decision in 2022,
but let me get
which I think relate to the rulings at this trial.
let me get to it.
Go ahead.
In 2018, this court recognized the fact that they moved to dismiss the plaintiff's quantum merit and unjust enrichment claims on the ground that there was a valid agreement.
Right.
And this court affirmed it, which means what? That the E&M agreement that Michael Langer signed is binding. What they went to Judge Bannon is to say to her, Judge, we want you to determine that he had no authority, but this court ruled on this.
It didn't necessarily, they said there was a valid contract agreement. I agree with you. But it didn't necessarily say that it was binding on every single one of the defendants named in this case.
Hold on a second. I'm going to get it. Give me a chance. In 2018, this court specifically said, and I'm reading, that Michael Langer signed the agreement on behalf of E&M.
Okay.
Okay? Which means, to the extent that he has that footnote, okay, this court said, hey, this footnote seems to indicate that under that agreement, he had the authority to bind everybody. Or,
No.
excuse me.
Excuse me. Okay?
Yes, Your Honor.
Watch yourself, counsel.
No, I didn't mean it that way. I just wanted
be
to...
careful. Don't raise your finger at the court.
I didn't mean it that way.
Excuse me.
I'm sorry.
Proceed.
No.
Respectfully.
Yes, of course, Your Honor. I'm always respectful, and forgive me if I did anything that upset you. But the point is, in 2018, this court found one issue. They found the agreement is valid. This court found Michael Langer was authorized to sign on behalf of E&M. And the only issue was whether or not the language of the footnote was sufficient to bind successors and assigns, okay? And now, what they said, which I really think was trying to mislead this court, they said, wait a minute, the intent of E&M when it signed that agreement was to bind only E&M, that only if E&M closed title on the properties, only E&M would be liable for a commission. That's what they said to this court. And it led to this court to find an issue of fact on this issue and this issue alone. Now, what we found out afterwards, Your Honor, they withheld documents. For example, they withheld a very important document, a memorandum that they gave to hundreds of their investors, telling them E&M had no intention of buying this property. They were going to syndicate. So now what happened? After this court sends it back because they withheld documents that should have been brought to your attention, that E&M never had any intention of closing title, we took their depositions.
That wasn't before the court on the 2018 motion.
Because they held it.
But that wasn't our issue.
I understand, but let me tell you what happened. So after they do this, Your Honor, we then subpoena the investors. Now they know we're going to find out what happened. So now we take their depositions. And look at our briefs, Your Honor. Mr. Ginsburg says, oh, we never closed in E&M. Okay? Mr. Langer, Sr., says, yes, we use E&M as an umbrella. We use this for every one of our deals, but we always close in new LLCs. So now they know the cat's out of the bag, Your Honor.
Well, that is a very typical procedure in the real estate business.
Right, that's what he said.
That this is nothing nefarious. That happens all the time. One company is going to acquire another asset. They create an LLC to hold the asset. That happens every day in New York.
That's what we said, Judge.
Okay.
That is why we said we put that language in, which meant, Your Honor, that under that agreement, the intent of the parties was that they were going to form new LLCs to take title, which therefore binds successors and assigns that this court found in 2018 was formed for that purpose.
Okay.
All right? So now we got over the hurdle that we're not entitled to a commission because E&M didn't take title. All right? And they've admitted it. They never take title. Okay? So now we get to the next issue, Your Honor, in terms of, now we have valid agreement. Okay? Now, the issue that this court found...
I wish you would get to the meat, because the meat here, right? The meat here...
Let me get to the meat.
Yes, please.
The meat is, they claim that my client was acting as a dual agent. They represented both sides of the aisle, right? Now, first of all, Your Honor, Look at the agreements. And this court found in the 22 decision.
So is your argument that your client was not on both sides of the deal?
No, no,
Okay.
no, no. Let me read what this court said, Your Honor. Okay, in 2022, this court said that pursuant to a series of agreements entered into in May of 2013, that includes the term sheet of May 2019, that includes a forbearance agreement, which and even the commission agreement that she signed with Mr. Singer, the owner of the properties, she was to be paid a commission solely for doing an unwind of the transaction. That's all she was supposed to be paid. Now, look what you said in 2022. Pursuant to those agreements, she worked a termination to unwind a purchase option, okay? Then you said, and the language is very critical, on November 14th, the unwind transaction was completed, which means that's what she did. She negotiated the unwind, following and as a result of the closing of the properties.
I mean, I really love how you're reading that from the beginning of the order and not looking at what we actually said, where we say we find that even if plaintiff was judicially stopped, unresolved issues of fact exist with respect. Like, how do you get over that?
I'll get over it, because counterclaims, they have the burden of proving, as this court said in 2022, not that she was hired as a broker on the sale, but that she undertook certain activities that made her the broker, okay? That's what this court decision said. And therefore, they said, when she said it's one transaction.
If we say that there are questions of fact,
yes,
where do those questions of fact get flushed out?
Your Honor, they had the burden.
Counsel, please.
Let me address it.
Answer her question.
I'm gonna
Where do issues of fact get flushed out?
At trial.
In front of a jury.
Right.
Did the jury here get a chance to flush those out since the judge precluded the evidence they required to assert their counterclaim?
Can I address that, please, Judge?
Please.
Okay.
I've been asking you to do that for the last 4 minutes.
Give me 2 minutes.
You've got 1 minute.
All of the Galanta documents that they refer to, okay, have nothing to do with the fact that she was a broker on the sale. If you look at the complaint that Galanta filed, he said he was hired only on the unwind, and he sued her on an oral agreement saying that they were supposed to share the unwind commission only. There's nothing in the documents in
Look,
Galanta.
you are arguing the merits of the issue, and our questions are geared toward whether the parties here on the other side received a fair trial in light of the preclusion of evidence that at least it certainly seems that it is relevant
But Your Honor,
and material for the jury to have considered this evidence in the trial below.
but
That's the issue.
And you might have been, successful in your position, but we'll never know that because the jury never heard that.
Your Honor,
So,
let me.
and so why isn't it proper for it to be remanded on that basis?
Let me tell you why. Because, first of all, you have a contract signed by Mr. Singer where he claimed and represented that he had no broker on the sale. That's number one, okay? Nobody denies that fact. Number two, they told the judge they were going to call Mr. Singer, the seller, and Mr. Fruckhand, who signed the contract that they took over by assignment. They were going to call them as witnesses to prove that Mr. Singer either hired her or that she did something as a broker, okay? We waited. Last minute, we're not calling them. So they never called Mr. Singer. They never called Mr. Fruchthandler. There was no testimony by anybody that she did anything to act as his broker. All we have is a contract signed by Mr. Singer saying he had no broker. And then if you look at their responses to the interrogatories, Judge, which are admissions, we were asked, what did Mr. Singer tell you? Look at the record. They said, Mr. Singer told us that she was hired only to do an unwind. I paid her a commission only for the unwind, and she had nothing to do with the sale. So the only testimony before the court, right, was their admission that Singer told them she had nothing to do with the sale.
What's also before the court is what was precluded.
Yeah,
but I've heard your arguments. Thank you.
Your Honor.
Counsel, sit down.
Okay.
Rebuttal.
A couple of quick points because I think Your Honors have most of it, but
2 minutes.
Obviously.
Holding you to the fire like I held him. Go ahead.
Obviously, the reason why the only evidence was before the court was evidence that the plaintiff put in was because the defendants were precluded from putting their evidence. And importantly, when this issue first came up before the prior judge, the judge was clear that the statements that George and Malone made in the Galanter case were not only relevant, but they raised the question of fact as to whether the plaintiff, through Malone's words and actions in Galanter, assumed the role of Singer's broker for the sale of the properties. And that was the question of fact. And that's at 2021 Westlaw 4523607 on page 10. And this court affirmed that that was the question of fact. So the jury was entitled to weigh that evidence and never got the opportunity to weigh it. And then I just want to follow up.
I'm sorry, I just want to take your take on one point your friend made, that you indicated but ultimately did not call either Mr. Singer or the principal of FBE.
We did not call them because it was unnecessary. At that point, our case had been completely compromised already, and we didn't need them to establish it if the jury had a fair inference and was given the opportunity to weigh the evidence. What we know is that Georgia Malone's company got $2.45 million at the closing of this sale, where we say she was the seller's broker, and that's why she was paid. So that the fact that she got the $2.45 million at the closing, at the sale, that she had admitted that it was part of one and the same transaction and had prevailed on the Galanter action by claiming they were the same transaction that she received the broker, was sufficient for a juror to decide that she was the seller's broker. And they just never got the opportunity. And on the question of remand, I would note that this case was not a commercial division case, and it just kind of ended up with Justice Bannon. So on remand, it would be appropriate to be where the case would be. And as co-counsel said, there are other issues related that are in front of Justice Kim. Thank you, Your Honors.
2 minutes.
So very quickly, I think Your Honors get it. But to be clear, we get along well, but we're not the same. So we didn't call Singer, we didn't call Fruchthandler because it was obvious it was futile. Because any question that we would have asked them, we had been precluded from asking dozens of times on the premise that the subject matter of whether or not there was this dual commission and dual agency was off limits. And that's one thing that I want to say here is Your Honors serve a very important purpose in New York and in society of establishing what are legal doctrines. This law of the case, the idea that something that, to my understanding, means that prior decisions in a single case are binding on later proceedings in that case, is quite different from the idea of extrinsic facts that are noticeable or can be put on as admissions or testimony are somehow not they are off limits. So I respectfully request that there be some treatment of this whole idea, because I do think it's confounding and confusing, the idea that you can't go back. And it's especially relevant in a case where, unfortunately, it's been going on for so long. It's wasted a lot of your time. And what we really want to do is knock it down very clearly and carefully. That law of the case certainly should not disallow somebody from being held to account for what they've said in another court under oath when they said they did get a commission for that transaction.
Thank you. This is not a trial, counsel. Counsel, this is inappropriate, okay?
Thank you, Your Honors.
State of New York versus JP Morgan Chase. Good afternoon. And you guys are the tough case. Everybody get your seats, get comfortable. We're gonna be here for a little while.
Get a snack.
Right? All right, let me get my clock ready here. 12 minutes.
Thank you, Justice Manzana Daniels, Canon Shanmugam of Paul Weiss for appellants. May it please the court. The relator in this case is seeking to convert an ordinary breach of contract action into an action under the False Claims Act. But Justice Borek permitted relator's claims to go forward even though relator cannot satisfy multiple elements for False Claims Act liability. Now, most of Relator's claims, its claim concerning invoices or notifications that were submitted to private parties, its claim concerning rate reset notifications that do not demand payment, and its claim concerning liquidity invoices that do not demand payment for remarketing services can easily be put to one side. That leaves Relator with its core claim, which is the claim that invoices for remarketing services constituted actionable false claims. But those invoices did not make any implied false certifications. They made no specific representations, whether explicit or implicit, about how defendants exercise their judgment or perform their services under the relevant contracts, excepting...
But they didn't, the point is that they had to exercise some judgment, right? Not just pass through the judgment of others.
That is
Am I right?
That is correct.
Okay.
When you look at the Relator's theory here, Relator's theory is really that we failed to exercise our judgment in their preferred fashion. What is the best evidence of that, Justice Manson at Daniels? It's exactly what they say in their brief. It's that we shouldn't have grouped VRDOs into buckets, that we shouldn't have considered VRDO inventory when we were setting our rates, that we failed to remarket VRDOs to a broad array of different investors. Now, a fundamental problem with that is that if we were here in a case brought by the state against us for breach of contract, there is no contractual provision that requires us to exercise our judgment in any particular fashion.
But sir, are you required to at least, where I'm kind of likening this to where discretion is given to an actor under a normal contract? This one's obviously more sophisticated, but you'll see where I'm going with this. So a party is imbued with discretion in how they're going to act under a contract, and I believe the party has a duty not to act arbitrarily in exercising that judgment. Could we kind of liken their theory here to that, or am I off on that?
I certainly think, Justice Hagen, I take the point, but I think that we would say that in each of these respects, we were in fact exercising our judgment appropriately. But I don't want to lose the woods for the trees here, because this is not a breach of contract case. The starting point for this analysis, I think we both agree, is the United States Supreme Court's decision in Escobar, which really sheds light on how to conduct this implied false certification analysis. And I would note parenthetically that I think Relator has abandoned any argument here that there's some facial falsity on the face of the invoices for remarketing services. And of course, the New York False Claims Act, the Court of Appeals has said, should be interpreted coterminously. The language is similar to the Federal Act in this regard. What Escobar stands for, in our view, is the proposition that you have to have some specific representation in the invoices that can be the hook for the theory of falsity. It is not enough simply to say, we have an invoice here, we can read in falsity from an omission. Now, why does that make sense? I should pause here and just explain why I think this theory is consistent with common sense. It's because if you went so far as to say the submission of an invoice is the equivalent of an express warranty that says you've complied with every contractual obligation, and obviously you could have such a statement in an invoice, that would be a somewhat unusual invoice, but if you had that statement, then you would have the falsity. If you accept the theory that a bare invoice is sufficient, then you really are collapsing this into a breach of contract case. In other words, you are saying that every invoice carries with it an obligation to comply with every contractual requirement. If you fail to do that, you are on the hook for the massive damages under the False Claims Act, and massive damages, of course, to the relator, not to the state, the counterparty to the contract. Now, how does Relator deal with this pretty obvious difficulty with its theory? Well, I think that the closest thing that Relator cites in its brief, and of course my friend can come up here and I invite him to say if I'm wrong about this, but I think the closest thing that they come to a specific representation is the statement that in some of the invoices, they say that they were submitted per or in accordance with the relevant remarketing agreements. Now, let me pause there and just note that that's only some of the invoices. In fact, as to two of the defendants here, so Citi and Morgan Stanley, their invoices did not contain those statements at all. Their invoices were truly bare bones. But I want to make clear that as to the other defendants, we think the analysis is the same for the simple reason that on its face, that is not a representation, much less a specific representation about the services that were provided. Instead, it's merely a representation about the submission of the invoices, namely that the invoices were being submitted in accordance with the contracts. And so to the extent that they were being submitted on a quarterly basis, that was in accordance with the contracts.
So can I ask you a question? And I'm sorry if it's confusing, but I'm trying to think of the things I want to understand a little bit better. There seems to be a claim, it's under the conspiracy claim, that all of the defendants were at some point working together to come up with indices that were, that were not correct, or that they could change them, or they were sort of just making them up as willy-nilly, and if somebody complained a lot, they would sort of change them around, and that shows that they really didn't have any value, and you were working with this guy from with Standard & Poor's. I mean, I remember these cases, when I handled some of them. I don't think that's been happening since 2012, but what were they claiming about that, and how does that fit into this?
Sure. So Justice Kapnick, just to explain how this all fits together, because I realize that there is a lot going on here. Everything that I've just said goes to the question of whether or not there was falsity on the substantive claims under the False Claims Act. Now, there is this parallel conspiracy claim in the case, and it is important for us that this court address that claim because the damages are similar, they're potentially joint and several and the like. But let's start with the legal requirement here. To have a conspiracy, as this court is aware, you have to have an agreement. And here it has to be an agreement to violate the False Claims Act, an agreement to submit false claims, and the alleged period, as you say, is this 12-year period. Now, how do the indices come into this? I think this is very different from all of the cases over the years involving indices for a couple of reasons. First of all, what were these indices? These were indices that just set out what the going rates were for VRDOs. Remember that when VRDO rates are reset, that does become public knowledge immediately. So these indices are not adding that much to what is...
And it's done in a rather frequent basis.
And it is done on a frequent basis. As we say, the VRDO rates are set typically daily or weekly, and there are thousands of these VRDOs, which explains why bucketing and the like makes good sense. Leaving that to a side, I want to go right to the heart of your question now, Justice Kapnick. What is it that was claimed about these indices? Well, of course, participation in indices itself has often been said to be pro-competitive. The theory has to be that the information that was contained in these indices somehow facilitated a conspiracy to set rates in the future on these thousands of different VRDOs. It's hard to see how the indices themselves could do that. Part of the claim here is that the person at S&P who was responsible for the indices was providing some of the backing data, parenthetically on an unsolicited basis, to the defendants. But again, it's hard to see how that either could facilitate the setting of rates in the future on all of these VRDOs. And the only other evidence of conspiracy to which the relator points are these few scattered messages, none of which were between two of the defendants that are before you today. And those messages themselves simply contain general impressions about the market, speculation about various indices, and the like.
So now, can I ask another question that, in reading your briefs, I was just a little confused. Initially, I think Judge Barak dismissed all the relators' claims that had anything to do with the public conduit bonds. And then on re-argument, he put them back, finding, I don't know, I forget, I don't want to go with the order, but he did put them back in, right, at re-argument. And I thought that there had to be some involvement with government funds in order to have these False Claims Act, and so I'm a little confused about that.
I think you're right to be a little bit confused because I think his reasoning is a little bit inconsistent in this regard. The straight line on the conduit bonds is that a claim can be actionable if it's presented to a private party, but only if the government has provided a portion of the money being claimed. And there's no dispute of fact here as to how these conduit bonds work. In this context, the government is serving at most as, in the words of the US Supreme Court, a passive throughway. The funds here from the purchaser flow through to a private issuer. That's the whole point of a conduit bond, is that the government is serving as the conduit. The private party gets the funds and can use them for certain specified purposes. And under the reasoning of the US Supreme Court in the Wisconsin Bell case, that is insufficient to satisfy that requirement that the funds be provided by the government. And I want to say just a word, because I know my time is short, about the two other categories of claims that I alluded to at the beginning. With regard to the rate reset notifications, those are easy in our view because they simply do not request or demand payment. They are what the name suggests. They are literally a notification to the issuer of what the rates should be. To the extent that there is an obligation to pay interest, that obviously flows from the underlying issue-in documents for the bonds themselves. And finally, with regard to the liquidity invoices, nothing in those invoices was false either, but there is the additional point that the invoices themselves did not seek payment for the remarketing services that were allegedly insufficiently provided. And on this point, we would refer to the reasoning of the California Superior Court decision that is appended to our brief, which I think sets this out in some detail.
Excuse me, sir, I just have one question for you. Who is responsible for the payment of the fees with respect to the remarketing?
So I think with regard to the remarketing invoices, certainly if it were a conduit bond, it would be the private party. If it is an ordinary bond issued by the state or a municipality, the state or the municipality.
So the conduit bond, the fees associated with that would be bore by a private party?
I think as a practical matter, I believe that that's correct.
Okay.
You have 15 minutes.
Good afternoon, Your Honors. Seth Greenstein, Constantine Cantor, may it please the court.
Can you just pick up on that topic in terms of the damages or the fees that, how is the government involved? Or do you need to show that somehow?
Right. So the way that the government is involved in conduit bonds is the government is not just a passive throughway. They create the bonds. They give the tax exemption to the conduit borrower. They sell the bonds. They lend the proceeds from the sale to the conduit borrower. Now, that's not the end of the government's involvement with this, because in the views of the IRS, because this is a tax-exempt transaction, the government is always the taxpayer. If there's anything that happens to the bond that breaches the tax exemption, the government is on the hook for it. If there,
the government would then have recourse against the holders, no?
they might have recourse against the conduit borrower, correct. However,
They might.
well,
But the government isn't in the business of losing money, so I would imagine that these are structured in a way to try to ensure that the government, right, is made whole at the end of the day.
they are, which is why the court, why Justice Borach found that the government itself did not incur any actual damage other than the money that was provided. Under the statute, as this court found in the first case, a claim means a request, demand, where it's made to another recipient if the money or property is to be spent on the government's behalf to advance a state or local government program or interest, and if the state or local government provides or has provided any portion of the money or the property requested or demanded. Here, all of the money is provided by the government's action in issuing the conduit bond in the first place. And I think the court should, the word provide is given a very broad definition by the Supreme Court in the Wisconsin Bell case. It says even if a UPS driver provides a package to the customer, even though it's never been sent by the UPS driver, and the UPS driver merely delivers it. It's still provided by them.
Is there any material difference between the terms that the Wisconsin Bell Court was construing and the terms under our state finance law?
No.
Such that the interpretations they were giving to that word, maybe we in New York State applying, construing our own state finance law might give a different meaning to?
In all respects that are pertinent to this case, the language in the federal FCA and the New York FCA are the same, Your Honor. So this is not an ordinary breach of contract case, but in fact, breach of contract cases commonly are the source of False Claims Act cases. If you look back to the original False Claims Act, or the reason the False Claims Act was enacted after the Civil War, it was because of a failure to sell guns that worked to the Union, right? That's a breach of contract, but also because it was a knowing failure to deliver what was promised and what was represented to be in the claim documents, it was also fraudulent. And that is exactly what we have here, Your Honor. So Justice Borak went through 21,000 pages of record and heard 10 different motions and heard 7 hours of argument and came out with a very well-reasoned opinion based on the facts. And it was a split opinion. Now, one thing that I think is really important to understand is the one issue that my opponent did not address, which is materiality, right? I mean, the gist of this transaction in the first place, from the point of view of the issuer and also understood by each the defendant, each of the appellants in this case, is that the obligation of the remarketing agent is to get the lowest interest rate that, using judgment in light of prevailing market conditions, would allow the bonds to be sold at par and clear the market. But lowest interest rate, all of the issuers said that. All of the defendants said that. All the defendants' witnesses said that. That is the key, the sine qua non, in the words of one of the defendants to the New York Attorney General's office, the raison d'etre of the VRDO is to get the lowest interest rate. So when you look at a remarketing services invoice that says, we've provided the remarketing services, if you look at a rate reset notification that says, here is the interest rate, the only possible thing it could mean is that this represents the lowest interest rate and that they've fulfilled their obligation. That is the only thing, which is why, I'm sorry, Your Honor, please.
You can finish your sentence, but I just wanted to know the fact that there's still this continued course of dealing. Does that matter at all to materiality?
It does not, Your Honor. Under the Escobar case itself, it says that actual knowledge of the fraud is what's required. Now, if you look at the cases that we cite in our brief and that the banks cite in their brief, in those cases, the government did an actual investigation and found fraudulent conduct and still decided to continue to do business. It's absolutely clear that allegations, even if it's gone to this stage, do not constitute actual knowledge that would allow that kind of government continuation defense.
What was the falsity? Because defendants are using their professional judgment to generate certain rates. So are you trying to establish that those rates themselves were false, or what is the falsity you want to establish here? And obviously I understand there's like three different, I won't use the word buckets, three different classes of claims that you have, one relating to the remarketing, then the liquidity, and then the resetting of the rates. So, but what if, as to, we want to take them in turn, what is the falsity you're trying to establish, and therefore there would have to be tribal issues of fact on?
Right. So first, let's talk about the facts that are false. The first fact that is false, of course, is that it is not the lowest interest rate. Our experts showed by analyzing the marketplace, by analyzing all of the rates, that in fact the rates that were being reset were significantly inflated, at least twice as much inflated over the prior period that is not covered by the complaint. And one of the easiest ways to show this, Your Honors, is by simply looking at the principle. It's a maxim of municipal finance that tax-exempt securities should trade lower than taxable because there's a taxable equivalence there because you get a tax break. So a couple of percents that you would save because of the tax is taken into account in that. So tax-exempt VRDOs should always trade lower than taxable securities.
And how do
But
we?
what's happened in
how would we or try or factor in the professional judgment that was contractually given to the defendants in setting those rates?
Right. So, Your Honor, the facts that were shown indicated that no judgment was being used. There's an abdication of judgment. The fact that you're obligated to use judgment means nothing if you don't actually use it. So in this case, there was collusion, where they were exchanging in advance rates that were to be set the next day. It was on a Tuesday. The weekly rates are always set on Wednesday, and that go for the following week. They were exchanging actual rate information. They were exchanging not market color, but indications of where they were going to be resetting their own rates the next day. That's through the direct communications. That's through the secret PARS index, which wasn't really an index. It was also giving each of the participants, the secret participants who were privately invited to join this, a breakdown of exactly where all the other entities, all the other competing RMAs, the largest RMAs, were setting their rates for the next day, okay? So that's not mere market color. That's collusion, number one. Number two, inventory, I think, is another clear example, okay? It's not just merely saying, well, we have the right to get rid of our inventory. There have got to be dozens of documents in the record that say that rather than saying, okay, we have some excess inventory, let's go out and get the lowest rate. What they say automatically is, we've got to move $600 million of bonds because our inventory is too high. Raise the rates and get them out the door. Absolutely, if you look at, document after document that says that. For example, there was one where one of the New York issuers complained that their rates were 20 to 40 basis points above others, and in fact, they were higher than taxable securities that were comparable. Internally, JP Morgan explained it. Somebody said, we all know what happened earlier this week. We had tons of inventory, and we priced it to move. That's not getting the lowest rate. That's self-serving their own business interests in trying to get the inventory off of their books. So that's number two. Third fact that a jury could take into account, of course, is the characteristics analysis that Mr. Wendt performed, where he basically said, okay, here are the characteristics that everybody says are important to look at when you're resetting a rate. And so he said, okay, let's look at, 5 of them, keep 1 of them, here are 6 of them, let's keep 1 of them constant and look at the rest. And what he found was that they had inverted relationships from what you would ordinarily expect to see. Bonds that were, subject to alternative minimum tax were trading, better than the ones that were not subject to alternative minimum tax. High-risk bonds were trading better than low-risk bonds. These make no sense to anybody who has any experience in the municipal bonds industry, but yet this is what happened, and it didn't happen just sporadically. This is what happened year after year after year over a 12-year period. And bucketing, by the way, is not just setting rates together, grouping them together. The bucketing that's being complained of, and that was demonstrated by Mr. Wendt's analysis, was that bonds that were very dissimilar, totally dissimilar characteristics, corporate bonds versus bonds that supported low-income housing projects, in totally different states. Totally dissimilar bonds that should not have traded together, but yet week after week after week, for quarters, sometimes for a year or more, we're getting exactly the same rate changes. It shouldn't have happened. This is not something that would have happened had anybody been using judgment. And in fact, the record shows judgment was not being used. Nobody was being supervised. The people who were on the front line actually performing the rate setting were not submitting their rates to somebody for supervision or for review. What happened was, if an issuer complained that they weren't getting the rate that they were supposed to get, they fixed it. But they didn't actually do any introspection to decide, well, we've gotten a lot of complaints lately. Is there something wrong that we're doing with our practice? Are we really getting the lowest interest rate? Nobody did that introspection.
Counsel, was there any evidence that that this collusion or conspiracy or, you know, these setting the rates continued after 2012?
Well, after 2012, after the LIBOR scandal came to
Right.
light, overtly it stopped. But so everything we have after that is circumstantial. There's no paper trail the same way that there was before. The circumstantial evidence we think is most powerful under the circumstances is what happened in December of 2015. The court may remember the Federal Reserve kept 0 interest rates for the federal funds rate for 8 years before December 2015. Suddenly, the Fed raised rates 25 basis points, 1/4%. Immediately, every single other municipal security jumped at least 25 basis points, except tax-exempt VRDOs. They stayed flat. But suddenly, come February and March, they all went up in unison from all of the different RMAs, and they all went up higher than would have compensated for the 0 rate that was maintained before.
Sir, could I trouble you to switch gears dramatically?
Please.
With respect to the invoices for liquidity, could you address the scienter element on that?
Yes. Well, for those, I think what Justice Borach found was that this is all part of a highly integrated transaction. That, in fact, all of them depend on the lowest interest rate promise. So, for example, letters of credit are drawn upon to pay the interest to the bondholders. Letters of credit are drawn upon to pay remarketing fees to the remarketing agents. They're also drawn upon to pay letter of credit fees to the letter of credit providers. So that's part of it. Another part that the court noted was that when a bank is seeking an underwriting engagement with the state, they will not just propose underwriting, they'll propose, well, we can do the underwriting, we can do it soup to nuts, we can do the remarketing part of it, we can do the letter of credit and liquidity part of it as well. And as our expert found, 75 to 80% of the fees that were paid for liquidity were paid to an affiliate of the remarketing agent. They were all remarketed, they were all marketed to the banks, to the issuers together.
So you're saying that the defendants in many of these cases were serving as both the remarketing agent and the liquidity support provider on these same VRDOs?
Absolutely, Your Honor. That's not in dispute. That's absolutely not in dispute in this case. I see that my time is up. There's so many other things that I wanted to address, but I think where I will leave you is where I started, which is that this is a very complicated case. It's before you on summary judgment, where the only question is, were there enough facts to go to the jury? And what Justice Borach found after combing through the 21,000 pages of record, after hearing 10 motions, 7.5 hours of argument, and all of the dedication that he made to the case prior, is that the facts remain. He said there was a mountain of evidence that supported Relator's claim, that there was copious, contemporaneous, persuasive evidence that supported us. But nevertheless, because of the affidavits that were submitted on summary judgment by the defendants, even though he said they're somewhat self-serving, they created questions of fact. Those questions of fact mean that summary judgment was denied properly to the defendants in this case, and we would ask you to affirm.
You have 3 minutes.
Thank you, Justice Manson and Daniels. I think I can cover my friend's arguments in 4 points on rebuttal. First, let's talk about the conduit bonds. My friend pointed to the tax benefits, the fact that these are nominally government bonds. But under both federal and state law, the statutory requirement is that the funds themselves be provided by the government. And so you have to follow the funds. And there's no dispute, I heard nothing to the contrary from my friend, that the funds here flowed directly from the purchasers of the bonds to the private issuers. And this is therefore a far cry from the facts of the Wisconsin Bell case, where the government...
So in a conduit bond situation, the investors pay their money over to who?
So the investors pay their money ultimately to the private issuers. It may be that they briefly sit with the government, but they end up directly going to the private issuers. And therefore, that is why this is different from Wisconsin Bell. Remember there that the government was collecting funds from civil settlements and restitution payments, and then those funds were going out. So there was affirmative government action in the flow of the funds. The funds could be said to be government funds. I want second to go to the issue of falsity. My friend spent a lot of time talking about how the rates weren't the lowest rates, faulted our clients for wanting to get inventory off their books, though the whole point here is that the goal is to clear the market of these bonds. But where is the specific representation here? I invited my friend to come to the podium and disagree with me if he thought I was wrong about their best example of a specific representation. He didn't even make an effort at the podium to defend the claimed representation that the invoices were being submitted per or in accordance with the underlying remarketing agreements. And absent that, you're left with bare bones invoices. And if I could point to the clearest error in Justice Borach's opinion, it was that he said that under Escobar, bare bones invoices are actionable. That's just wrong. Third, on conspiracy. I want to underscore that if you agree with us on falsity, there's no need to get into the evidence of conspiracy. We would be entitled to summary judgment on that claim. But I would note parenthetically that as to the evidence that Justice Kapnick and I discussed in my principal argument, that is the supposed mountain of evidence that Justice Borach relied on to find scienter on the underlying substantive claims, and it is insufficient for all of the reasons that I gave earlier. In order to have scienter on the underlying claims, you've got to have knowledge or reckless disregard. That depends on the subjective state of mind of each defendant. Finally, the stakes in this appeal. I agree with my friend that contract claims can sometimes be False Claims Act claims. Obviously, that's true. We're talking about the government. But not all contract claims can be False Claims Act actions, and that would be the result of affirming here. And the last thing I would say on this is that Justice Pitt-Burke, you pointed out the fact that in this case, the government continued to do business with our clients. We do think that that is relevant to materiality, but it's also relevant to the broader issue here. To this day, as we're standing here in 2026, the government has not sued for any breach of contract claim. And so think about the oddity of an affirmance here. You would be permitting a private relator, not even a whistleblower, as is usually the case, who has inside knowledge about the state of mind in a company. The relator here is literally a Delaware limited liability company formed for the purpose of bringing these sorts of qui tam actions.
They weren't an investor, they're just, Edelweiss Fund was not any kind of investor?
It was created by an individual, John Rosenberg, for the purpose of bringing this case. And the reason why I think that this is such a potentially terrible precedent is that if this court were to affirm Justice Borach's reasoning, it would really make New York an outlier with regard to the elements of the False Claims Act that we were discussing today, and it would make this state a magnet for precisely these sorts of non-fraud fraud claims, these sorts of breach of contract claims that are being dressed up as claims under the False Claims Act. And so for that reason, we would ask for reversal.
Thank you so much. Be patient in waiting for the decision, okay? There's a lot of material to cover, all right?
Nice job.
And last but not least, we took it along. Yeah.
Yes.
HSBC Mortgage versus Lau.
Yes, good afternoon. My name is Zong Lau, the appellant pro se. Yui Lau is the co-appellant pro se. We are the children of the deceased defendant mortgager, Sankei Lau. This appeal concerns a sale order in a residential mortgage foreclosure action and a denied cross motion. The cross motion, we sought two reliefs. First, substitution of necessary parties, heirs at law, distributees, and the successors of interest of our father, those parties being us. The second part of the deny cross motion, we sought to assume the mortgage via declaratory judgment pursuant to CPLR 3001. Just to provide some context, our father, Sankey Lau, died post-judgment in November 2020 during the...
What?
Sorry?
Post-judgment.
Post-judgment, sorry. Died post-judgment in November 2020 during the COVID-19 pandemic. Specialized Loan Servicing LLC is the judgment creditor and the plaintiff respondent in this appeal. The gravamen is that the trial court overlooked the limitations of judgment finality. Okay, Specialized has no standing to conduct the sale because they assigned the mortgage post-judgment in 2019 to LSF10, who is a non-party and has neither filed anything nor participated in the underlying action. So CPLR 1018 does not apply. And it doesn't apply post-judgment, as is the situation going on right now. The specialized judgment of foreclosure and sale was issued in November 2018. It does not have a successors or assigns provision. Since a specialized judgment is not integrated with the successors or an assigns provision, then there must be an assignment of judgment, for which there is none. Additionally, since Specialized sold the debt 7 years ago in 2019, they also can no longer assign the judgment because they are non-holders of the note and mortgage. So accordingly, the specialized judgment and foreclosure and sale should be permanently stayed. Specialized is also barred from conducting the sale pursuant to CPLR 5019A, which states that a judgment or order should be stayed if it affects a substantial right of a party, and that's what happened here. 2 rights were denied in our cross motion. In the first part of our cross motion, we sought to be substituted and joined in this action, and we have every right to do, but that was denied. We have every right to be substituted in the capacities as heirs at law, distributees, successors in interest, and the owners of the equity of redemption, which are all supported by controlling precedent by the First Department, Second Department, and the other 2 remaining departments in New York. And the second right that was denied in our cross motion, the right to assume the mortgage pursuant to the Garn-St. Germain Depository Institutions Act of 1982 and RESPA of 1974. RESPA being the Real Estate Settlement Procedures Act, states that children of a deceased borrower can assume the mortgage and that we are exempt from the due on sale clause. Specialized also demanded deficiency judgment against our father. So the trial court should have stayed proceedings pending a legal...
Wasn't that claim withdrawn?
Well, actually, that was an abrupt waiver made in 2024, 6 years later. So that's actually a collateral attack on their own judgment. They recanted their own relief that they sought. They wanted deficiency, and then they said they took it back 6 years later. So it was a matter of convenience for them. And they lost their standing. They assigned the mortgage to LSF10.
Okay. Your light is on. You'll have time on review.
Okay.
Good afternoon, Your Honors, and may it please the court. As was set forth very well, this matter went to judgment in 2018. Case law is clear that a judgment of foreclosure resolves all issues that were litigated or should have been litigated. Since that time, somehow we're still here in 2026 now. One aspect of the underlying motion was a motion for an extension of time to sell. That was necessitated by the numerous orders to show cause seeking stays of the deceased borrower, and then thereafter the appellants here. So that aspect of the motion was granted and should have been granted accordingly. The cross motion argues 2 points. One, that they should be allowed to assume the mortgage.
Assume a mortgage that has already, where a judgment of default has already been granted?
Your Honor, that's exactly what I was about to get to. Once once a foreclosure gets to a judgment, the judgment becomes the operative document. You go to sale pursuant to the judgment. The mortgage is no longer assumable under those circumstances. Furthermore, as Your Honor set forth during, earlier, 2 points. Respondent argues first that the deficiency waiver wasn't necessary pursuant to the case law that's cited in my briefs. Further, even if it was necessary, the deficiency was waived as a matter of record, and the judgment, the operative judgment that I discussed before, provides that plaintiff may, operative word may, not shall or must, may seek a deficiency judgment. So I think it's certainly within plaintiff's prerogative to make that deficiency waiver, especially in light of the extended history of this case, a judgment since 2018, and we just couldn't go to sale. As far as standing arguments, the judgment is final as to all issues. As far as post-sale ramifications, a check can be endorsed just like a note can, a bid can be assigned. So I don't think those arguments impact the judgment and the ability to go to sale. Thank you.
You have 1 minute on rebuttal.
Yes, adversary stated that, that you just have a judgment and you can do anything, basically proceed with the sale. That's incorrect, because their judgment, we are in deference to that. It does not have a successor or assigns provision, as I stated, and they don't have an assignment of judgment. So if you didn't have that, then the second step would be an assignment of judgment. And they sold the mortgage in 2019, and they continue to prosecute and sell the home, yet they do not.
Case law, they're permitted to.
I'm sorry, case law actually.
Under our case law, they are permitted to if they initiated the action.
Actually, case law in the brief, I've cited it, they are not. They're supposed to have an assignment of judgment. Because, and also you asked a question to him, you said that, can you still assume the mortgage if it's gone to judgment? And I cited federal law, and it states you can, because in New York law, you can assume the mortgage until the home is sold. And that's what we did.
Okay, thank you.